There are matters to be heard by both juries this morning.
There, I think there's two. One is we had Dr. Cox scheduled this morning. Based on the conversation I received from Ms. Abramson yesterday afternoon, we put him on a call, so he's not here, but he was going to be the main witness in front of the Menendez jury. Today he'd be in front of both juries, but we had him and one other witness for the Menendez jury. So we need to resolve what the situation is with Dr. Cox.
All right, if you care to do that now, we can. I have indicated to counsel for Eric Menendez yesterday my preliminary ruling as far as the defense intention of calling psychologists who had treated Mrs. Menendez calling those individuals prior to the testimony of the defendants. And I had reviewed the document filed by the defense Friday on that subject. And I indicated to the defendant, Eric Menendez counsel, that my view was that the evidence referred to in that document filed on Friday is evidence that only becomes relevant after the defendants testify. And I did indicate to counsel for Lyle Menendez last week that if the court was to rule that these witnesses could not testify until after the testimony of the defendants, then the defendant, Lyle Menendez, who was going to be testifying immediately after these witnesses, should be ready to testify before them. And that's what I indicated to counsel again yesterday, and I asked them to relay that to you.
I got a phone call at the agreement in jail, and I got what I'm sure is a very short version. So since we weren't here to actually hear what the court's position was on it, I was wondering if the court might let us know what the thinking is. I'm not sure how detailed you got on your.
No, we didn't get that in any great detail. I indicated to counsel that I wanted to give you a chance to be heard. You filed a brief, and I was not going to invite great argument on the subject, but I'll certainly hear your response.
I would like to address the part in terms of the content of the testimony. I believe Mr. Burt wrote the brief, but he can address the legal aspect of that.
All right, I have read the document filed by the defense, as well as reports of interviews done by the defense of the various psychologists who have treated Mrs. Menendez in the past.
It would be our position that the testimony of Dr. Cox, Dr. Emery, and Dr. Summerfield would be material that would be appropriate to admit at this point in time, because it details the behavior of Mrs. Menendez and the condition of Mrs. Menendez from the period of late 1986 until the time of the homicide. It describes her as being obsessive, as being depressed, as being suicidal, being extremely unstable. And I think that this is the type of evidence which is admissible about the alleged victim of a crime under any circumstances, in terms of what their behavior is, in terms of their instability, in terms of them talking of death, doing things which escalate the situation. So it would be our position that the type of information which these people would testify to, including Mrs. Menendez drug and alcohol dependence, would be admissible even if the defendants did not testify. And I think Mr. Burt has done the legal part of it, so I will defer to him at this point.
All right, Mr. Burt, without repeating those things that I've already read in your brief.
I'm not going to repeat any of that discussion, Your Honor, but there were a couple of things I wanted to point out to the court. First of all, At the end of the people's case, we reached a situation where the people could have called Detective Zoller, I believe, to wrap up their case at a point in time when we were having scheduling problems. And at that point, we actually requested that that be done, and the court, in response, made a comment, something along the lines of that the court would not dictate the order in which the people had chosen to put on their case.
No, I've also said that during the defense in reference to the defense election of which witnesses to call.
Yeah,
I've said that more than once, and I've said it to both sides.
And my point in bringing that up is to indicate or to suggest to the court, if I understand the tenor of the court's comments yesterday, the court was concerned not so much with the question of whether this evidence was admissible, but when.
No, let me get to that point so that we don't get too far along.
Sure.
I am, at this point, not ruling whether that evidence is or is not admissible. I am not ruling on that at all. So whether I defer the ruling or not doesn't mean I'm going to let it in. So that is my analysis is that until I hear the defendant's testimony, their version of what happened on August the 20th, 1989, none of this evidence has any relevance and doesn't prove anything. And I disagree with Ms. Lansing's analysis that this evidence would be admissible regardless of whether the defendants testified, because it wouldn't. None of the evidence we've heard so far by the defense, other than impeaching evidence of prosecution witnesses, would be admissible unless the defendants testified. You wouldn't normally have this sort of evidence unless there was a defense version of the events, whether through the defendant's testimony or some other eyewitness to the events. And as we're aware, the only eyewitnesses are the defendants, the surviving eyewitnesses. So none of the evidence would be admissible unless the defendants testified.
All right, I'm glad the court made those comments. I'm not glad of the content of the comments, but they clarify for us what the issue appears to be. And it seems, Your Honor, that we did state to the jury in the opening statement the defendants would testify. We're pretty much bound to that strategy at this point. And the court, I think rightly, has exercised some discretion in allowing us to put in evidence which, as the court indicated, probably would not be admissible absent the defendant's testimony. We have committed ourselves to a certain line of defense here. We promised the jury they would testify. And it was in support of that opening statement and the line of defense of self-defense and heat of passion that I think the court allowed the testimony which has been received thus far about the victim's character and background. And to a certain extent, it's a tactical call on our part as to when in the defense case the defendants are most appropriately brought before the jury. And we realize the court has discretion to override our tactical judgment in that regard, but the decision on which witnesses to call and when has been made with the idea, as is typically the case in criminal cases, that the defendants would testify near the end of the case. And we have presented a profile of the victims and their personality traits through a number of witnesses, and the people have responded to that portrayal of the alleged victims in this case by contesting what we say is the essential profile of the parents. The evidence about the parents is relevant, I think, because it tends in reason to suggest that the type of behavior which the brothers will testify to did in fact take place. And the court is absolutely correct that, technically speaking, none of the defense case was relevant, and the court probably could have forced us at the outset of the case to call the defendants before we produced any evidence at all about the alleged victim's background. The court didn't do that, and as a result, the record now stands that the juries have heard a great deal of testimony about Mr. and Mrs. Menendez and about their behavior over a long period of time. And they've also heard a great deal of cross-examination by the people contesting that portrayal that we have presented to the jury. So at this stage of the case, we are in a position of representing to the court that we will be placing both defendants on the stand and testifying along the lines of what was suggested in our opening statement. We urge the court to take that opening statement into account in determining whether the court would exercise its discretion in essentially forcing us at this point to go forward with the defendant's testimony against our better tactical judgment when we have witnesses available who can corroborate the portrayal of the parents that we've thus far presented. So it's corroborative not only of the defendant's anticipated trial testimony, it's also corroborative that we presented to the juries. And the second point I wanted to make to the court is I don't think it's unusual to present evidence which in a strict sense is maybe more properly characterized as corroborative of the defendant's testimony. We cited the case, the McAlpin opinion, where the Supreme Court discussed the admissibility by the prosecution of certain profile evidence that they sought to introduce in support of their case in chief. And the court held that that evidence was admissible as anticipatory of the defendant's proposed attack on the prosecution's witnesses. And it was presented before the defense had ever mounted that attack. And because the circumstances revealed that the defendant would attack the credibility of the victim, the court in McAlpin said that it was proper in the people's case in chief to anticipate that attack and to address it through evidence. In the same way, we cited to the court a case which dealt with the fresh complaint doctrine, the hearsay exception for fresh complaint. And those cases also say that during the prosecution's case in chief, the prosecution can anticipate an attack on the victim's credibility and can address in their case in chief evidence which would technically not be admissible until the defendant actually mounted the attack which was anticipated. And it's really the same situation here. There is no doubt that the defendants are going to testify. They are going to. And there's no doubt that they're going to testify consistent with the evidence which was outlined in the opening statements. So at this point, I think the court can fairly say and because of tactical and scheduling considerations, we're asking the court to exercise its discretion to allow a witness that might technically be strictly out of order. Because this is the witness we had scheduled for today and had prepared. And it's really a situation where if the court does not allow this testimony at this point, as cooperative of the evidence that's already before the jury, then we're really stuck in terms of scheduling.
All right. Did Eric Menendez counsel wish to be heard at all? All right. Did the people wish to respond?
Yes, Your Honor. The defense has been afforded a great deal of latitude in the presentation of evidence, and I'm not prepared to argue the legal merits of whether or not Dr. Emery, Cox, and Summerfield should testify because I did not prepare that for today based upon the court's comments of yesterday. And unless the court is inclined then to grant the defense request to put on Drs. Cox and Summerfield this week, does the court wish me to address those issues?
No,
all right.
not quite yet.
Thank you. The defense has been allowed to put on the same type of profile evidence as was used in McAlpin, which was the testimony of Dr. Briere. They have been allowed to put on a plethora of repetitive witnesses on the issues that they deem to be germane. But I just want to point out that just because an attorney says their client's going to testify doesn't mean the client will. I can think of a couple of famous cases where defense attorneys stood up and opened an argument and promised the appearance of their clients and then rested their case before the client testified. So I don't think, I mean, in this particular case, the defense could change their mind too. They've gotten enough hearsay in front of the jury from their clients. They don't need to be subjected to cross-examination. So I think that until the defendants actually testify, that is probably time to make these issues germane. And if they don't testify, then most of this testimony we've heard so far is irrelevant. Now, under 1103, I think what might be relevant, whether or not the defendants testify, would be violent character traits of the victims, because this is a crime of violence. But as far as the other things that we've heard about, the coaching, the teachers, none of that is germane right now to any issue that could be raised by a homicide under 1103.
Well, just to respond to the last point, unless there is some evidence by the defense as to the nature of the killings that contradicts that offered by the prosecution, it wouldn't seem to me that any evidence of a character trait of violence of the victims would be admissible under 1103 of the Evidence Code. I don't think the defense is contending otherwise at this point. Their position is that the defendants will testify.
Well, I just think that there have been many cases, I mean, the Billionaire Boys Club, the first trial, the attorney stood
Well,
up.
I don't want to go into anecdotes here of other cases. It's obvious that, and as indicated by the defense in one of their earlier briefs regarding one or two juries, decisions as to which witnesses will testify and which witnesses will not testify change during the course of a trial. And what is indicated in a pleading or an opening statement is not necessarily what transpires when the trial actually occurs. I'm looking for the specific brief that was filed by the defense on that subject. I have recollection of those remarks being made by the defense. It was a statement made in the brief filed by the defense on June the 7th, 1993. And without, I know it's here, since there is a concession by the defense that they made that statement, and it's an obvious truism that things change and circumstances change during the trial or before the trial, which could cause decisions to be made whether a defendant does or does not testify. Other issues yet to be discussed in relationship to the defendant's testimony, such as whether one defendant will testify before both juries and things of that nature, could also have some impact on whether both defendants testify. There's still all sorts of things that can occur, but I am taking the defense position at its good faith statement of their intent to call the defendants. And I'm not disputing that. And I'm not making any rulings based upon anything other than what the defendants say that they will do.
Could I add one point?
Yeah, sure.
In general, I think it is a true statement to say that sometimes decisions change and defense lawyers can change radically their course of action. But in general, I think that typically happens after the people have rested, and the defense has to make a decision at that point on whether to go forward or not with any sort of defense. And there are cases where defense lawyers have stood up an opening statement and promised the defendant is going to testify, and then the prosecution's case and the defense's view has fallen apart, and the defense feels comfortable at that point in resting. But that's not the posture we're in at this point. And the defense has gone forward, and I think we are committed at this point to having the defendants testify. I don't think in a position where we could, at this point, stand up at the end of this case and say to the jury, we changed our minds, having promised them the defendant's testimony and having gone this far in our defense presentation. Because as the court itself recognizes, without the defendant's testimony, the evidence we've thus far presented becomes meaningless.
Well, legally it becomes meaningless, but there's obviously other impact that can result from evidence such as this that attacks the character of the victim, that goes beyond the legal issues that counsel were trying to establish. The remark by the defense in its brief of filed June 17th is on page 16 of it, wherein the defense says, quote, "The prosecution's speculation about the defense counsel's future trial tactics has no place in the analysis, and in any event, as every trial lawyer knows, trial tactics can't change," end quote. Let me go back to what we've been discussing here and respond to it. The defense is in its, by my recollection, at least its third week and perhaps fourth week of evidence. And the evidence introduced thus far primarily has to do with character traits of one sort or another relating to the decedents. The prosecution did not object to the introduction of this, the vast bulk of this evidence. In recent times, there have been, in the last day or so, objections made. But overall, the prosecution did not object to the introduction of the evidence and did not object to the order in which it was being produced, although it only related to corroborative evidence of the defendant's own testimony. The court has permitted this evidence, although during the course of its introduction, there have been some controversy relating to bits and pieces of the evidence as to specifics. But overall, any objective observer of the trial so far would see that primarily what the defense sought to introduce has been introduced during the course of the defense. At this point, the defense has indicated that it wants to proceed with testimony of therapists who treated Mrs. Menendez. There is a substantial issue as to whether that evidence is or is not admissible during the defense case or during any portion of this case. The only way it could be admissible under any theory is that which is put forth by the defense as corroborative evidence of the defendant's own testimony. And in reviewing the brief filed by the defense, that theory is put forth numerous times. On page 5, the brief refers to the testimony of the witnesses that will corroborate the testimony of the defendants. Page 12 of the brief refers to the evidence as corroborative of the defendant's testimony. Page 13 likewise refers to the evidence as being corroborative of the defendant's testimony. Page 24 uses the word corroborate. Page 25, the defense argues that the testimony of the experts is necessary to support the defendant's versions of the events. Page 26 refers to it as corroborative evidence. Page 31 says that the evidence of these therapists would be necessary to explain the defendant's own testimony. Well, looking at the offer of proof by the defense, this evidence could only be admissible under any theory if the defendants testify, and whatever they say is corroborated by what these therapists would say. And I have no way of knowing what the defendants will say as to what happened on August 20th, 1989, because that has never been presented to me and has not been presented to the jury as in opening statements or any other time. And I have no idea what the defendant's version of the events will be as to what they say the decedents did and what they say they did. And till I hear that, there's no way I can evaluate the proffered testimony of these therapists to determine whether their testimony could corroborate in any way what it is the defendants would say. So quite clearly, that evidence is not admissible until such time as the defendants testify. And as I've indicated, I'm not ruling that it would be admissible. I am not ruling one way or another. I just don't have a feel for it until I hear the defendant's testimony and perhaps further offer of proof from these therapists and refinement by counsel as to the specifics of what they would say. But that only can occur after I hear the testimony of the defendants and after the jury has heard that testimony to determine, for the court to determine whether or not this testimony could in any way corroborate their testimony. As far as the order of proof, quite clearly the court is very sensitive and concerned with counsel's right to present their case as they see fit. I don't want to interfere with that, and I wouldn't. It's your job to present the evidence and present it as you feel is most appropriate. But on certain issues, matters must be resolved before other evidence can be introduced, because there has to be some legal foundation for its introduction. And in this particular situation, that foundation would be the testimony of the defendants. And at this point, I can't see the testimony of these therapists being put on prior to the defendant's testimony. Counsel is correct that the court does have the inherent power to and authority to control or the discretion rather, to control and regulate the order of proof. And the court would do so in this situation. The court has the discretion under Evidence Code Section 320 to do so. And I don't find that in any way this is a situation where the defendants are being deprived of any due process rights or opportunity to put on their defense. They've had 3+ weeks to put on their defense so far. And as was indicated by Ms. Lansing last week, her intention was to call Lyle Menendez as soon as the testimony of these witnesses was completed. So it's not as though we are jumping so far ahead to the end of the trial that the defense is forced to leap forward a month or so before they intended to put on defendant Lyle Menendez. His testimony was impending, imminent, and was anticipated to occur this week one way or another. So the fact that it occurs a day or two earlier doesn't deprive the defendants of any due process rights whatsoever. The defendant was given notice, Lyle Menendez was given notice of this potential circumstance last week. I made it quite clear that this was something that could very well happen. And two more things here, and I certainly will. And reviewing the documents, also the briefs filed by the defense, today, or strike that, it was filed Friday and then again yesterday for hearing yesterday, but it's the brief relating to the therapist who treated the mother. All the cases basically cited by the defense that have any relationship whatsoever to situations such as this, and none of them really have a direct connection to this. They're all by analogy and cited by analogy. There's no direct case on point. Those cases all basically contemplated the testimony of the defendant and the evidence offered by any therapist as corroborative evidence. So my view is that the case has come to that point where the defendant indicated it would be calling Lyle Menendez later this week or first of next week. So at this point, the defense will be foreclosed from calling these other witnesses as corroborative witnesses until he testifies.
With regard to this case, I don't want to mislead the court in terms of my degree of readiness. We talked with the district attorneys this morning. We think that there's about a full day of litigation on various issues prior to Lyle Menendez taking the stand, issues that we need to know ahead of time. Once we have decisions on those issues, and there are a number of decisions I couldn't make with regard to his testimony. I know whether he's testified in front of one jury or two juries, what the scope of that's going to be, other pending issues, the attorney-client issue with regard to the 1211 tape, the 1016 issue.
Well, that issue I don't see as being germane until the issue of patient-therapist privilege is resolved.
We'd like to be heard on that. And what I'm suggesting to the court is that there are a number of unresolved areas. Before Lyle Menendez can testify, we need to resolve whichever of those areas the court is willing to resolve. And then I need a period of time in which to make the final decision with regard to his testimony. I can't just call him now because I don't know what kind of, I don't know how many juries we're testifying in front of. I don't know what the scope is going to be across. And so what I'm suggesting to the board is, if we don't have Dr. Cox today, and we have some other brief witnesses, if this afternoon we can resolve all of those issues with regard to what the testimony is going to end up looking like, I will need a day. I could be ready to put him on Friday. That's pushing it. I plan on putting him on Monday. The court did give me notice last week that this may happen. I also had to be prepared to put Dr. Cox, Dr. Emery, and Dr. Summerfield on this week in case the court was going to allow me to do so. So what I'm telling the court is I could be ready on Friday, but I could not be ready on Thursday to put Menendez on the stand.
All right, anyone else wish to be heard on scheduling matters at this point?
Well, Your Honor, we've been given notice this morning that there's a witness they wish to call tomorrow. I prepared a copy of that witness testimony. We're going to object to the witness testifying at all. I'll give this to the court now. So the court can.
Okay, I wish you would give me, when did you receive this?
About a half an hour ago.
Okay,
No, it's more like an hour.
whatever it is, I wish you would give it to me when you first determine that you have some objections so that I can review it before coming out.
Yeah, I can move that witness to Friday. I wouldn't bring that witness in for tomorrow. I don't know why the court is even bothered with that.
I don't know either. This witness is not testifying today.
No, you're wrong. And if there isn't going to be testimony from Menendez tomorrow, she's going to testify tomorrow either, because I wouldn't bring her in for.
This is only as to Eric Menendez?
No, it's as to both, but it's 5 minutes worth of testimony, so we can save it for a day when we're on the video.
Your Honor, as there's a witness that they intend to call today, I believe it's Mr. Phipps.
No, I don't know.
All right. Well, you were told that. We can only act on what we've been told.
Oh, we just weren't able to reach him to tell him.
Do you have any witnesses here for both juries?
Just one.
And how long will that take?
It's 10 minutes.
And then what else do you have?
Then I have 2 witnesses for Eric Menendez's jury, totaling.
All right. Do we have all the jurors here? Okay. Are you ready with the witness for both juries? Any hearing or any objections to that witness's testimony?
We already did this, Mr. Lowe.
Okay, then let's get both juries out, please.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
And we now have both juries in the courtroom, and to all of you, good morning. And we're now going to proceed with further testimony. The defense may call its next witness.
Skip Lowe.
My name is Skip E. Initial Lowe, L-O-W-E.
Good morning, Mr. Lowe.
Good morning.
Mr. Lowe, directing your attention to 1989 in the spring to summer months, did you attend some sort of a function in Beverly Hills?
Yes, I did.
And what type of a function did you attend?
It was a black tie affair.
Okay, and was this a benefit for some particular organization?
Yes,
Do you recall what organization was going to profit or benefit from this event?
it was some sort of a Jewish organization. That's all I know. I don't know if it was the City of Hope or whatever. I don't remember.
All right, and where was it that this benefit was held?
At the Beverly Hilton Hotel.
The Beverly Hilton?
Hilton. Mhm.
And are you able to recall the specific date that this benefit was held?
Around springtime, something like that.
Were you, did you attend the benefit alone or with someone else?
I escorted a lady,
And who was that lady that you escorted?
the actress Mamie Van Doren.
Now, when you arrived at the benefit, were you assigned a table to sit at?
Yes,
And did you know the people at the table, any of the people at the table at the time you arrived?
No.
How many people were assigned to your table?
I think about 10.
Do you know the names of any of them?
No,
Was there anyone assigned to the table that you sat at that evening that you recognized today in court?
no, except the boys.
Okay, when you say the boys, are you referring to two individuals who are sitting at council table?
No, just here.
Okay, I'm standing in back of a young man in a green shirt. Do you recognize him as having been at the table?
Yes,
Okay, and there's also another young man who's wearing a green check
yes,
shirt.
yes, yes,
Do you recognize him as
yes.
having been at the table? Now, were these two young men in the company of anyone else?
Their parents, mother and father.
And do you recall the seating arrangements? That is, who were you sitting next to?
I was sitting next to Mamie Van Doren, and they had a couple next to Mamie. And then Lyle, and then Eric, and then the father, and then the mother, and a Canadian couple, and myself.
Okay, so that Eric was sitting next to his father, is that
Yes,
correct? And during the course of the evening, did you have an opportunity to observe interaction between the two brothers and their parents?
yes.
During the course of the evening, did something unusual happen involving Mr. Menendez and one of his sons?
Yes,
Which son was involved in this incident?
Eric.
And what particularly did you see that happened?
Mamie Van Doren was talking to the father, and the father was talking to Mamie, and all of a sudden, Eric wanted to say something to Mamie Van Doren, and the father interrupted him and pinched him real hard in the arm and told him to shut up, dummy, I'm talking to you. And the boy just stopped, and Mamie and I looked at each other, and
All right, you finish the question.
All right, let me ask you another question. What tone of voice did Mr. Menendez use when he said, shut up, dummy?
very harsh and loud.
And when you say that he pinched Eric, could you tell us what specifically he did?
In the arm.
Okay,
Real
you're
hard.
indicating the upper arm area.
Yes, something like that.
Did Eric react in any way to what his father did or said?
He turned red and didn't say a word, and put his head down and took the fork and played with food.
Now, were you able to see whether or not Mrs. Menendez had any reaction to this incident? Did she respond?
She was talking to the Canadian couple next to her, and she seemed like she heard it.
Objection sustained, the answer is stricken.
Did Mrs. Menendez do anything or say anything that made you think that she had heard what her husband had said?
Seemed like she was out of it to me.
Okay, what do you mean when she seems like it was?
It didn't mean anything to her. It just didn't mean anything.
Objection sustained, the answer is stricken.
Was there anything unusual that you saw that evening about Mrs. Menendez's behavior?
Sustained.
But how long was it that you were at this benefit at the table with the Menendez family?
How long? I'm sorry. How long?
How long were you there that evening? Was it an
Not very
hour?
long. Not very long at all.
And after this incident occurred with Mr. Menendez and his son Eric, were you able to see how both brothers acted?
I think Lyle was a little embarrassed.
Sustained. Answer stricken.
Did Lyle do or say anything after this incident?
No, not at all. Neither of them.
Pardon?
Neither of them did.
Yeah, if you just back up, it would be.
Oh,
okay.
I'm sorry. Forgive me.
So you get a little too close.
Sorry.
That's okay.
Thank you. I'm an entertainer. I have projection. I'm sorry.
Okay, well, just don't project so close.
Thank
to the
you.
microphone.
Thank you.
Now, let me ask you to focus on the interaction between the two brothers that you saw that evening.
Right.
Could you describe how they were acting?
Can you be more specific, please?
Yes. Could you describe the demeanor of the two brothers subsequent to the incident which involved Mr. Menendez pinching his son and telling him to shut up?
It seemed like the father wanted to talk to Mamie Van Dorn.
Sustained.
Okay.
Answer stricken.
All right. I'm focusing on the
Okay.
period of time after
Right.
this incident with the father
Right.
pinching Eric.
The mother got up and left about 10 minutes after, went to the bathroom.
All right. And when she left to go to the bathroom, did she come back within a short period of time?
No, we didn't stay.
Okay. How long after the mother left to go to the bathroom did you then leave?
The father got up about 10, 15 minutes after, looking for her, evidently, I think. And Mamie and I just got up because she lived in Newport Beach, and she wanted to get home, and she thought the whole thing was very heavy.
Your Honor, move to strike comments of Mamie Van Dorn as being hearsay.
Sorry.
All right, the portion of the answer, starting with she thought and everything thereafter is stricken as hearsay and unresponsive.
All right. You said about 10 minutes after Mrs. Menendez left the table, Mr. Menendez got up as well.
Yes.
And at that point, did you leave?
Immediately, we just said goodnight, got up, and the two boys were the only ones at the table, got up and stood for Mamie and I to leave. The Canadian couple did not, and the other two couples weren't around, so we just left.
Okay,
We said
and
thank you.
why did you leave at that point in time?
Objection irrelevant.
Sustained.
Was there anything that had happened during the dinner which caused you to leave? At
Very
that point in time?
uncomfortable.
Excuse me. Objection irrelevant. Move to strike the answer.
Objection sustained, the answer stricken.
Let me ask you for a moment, Mr. Lowe, about how Mr. and Mrs. Menendez were acting towards one another during the course of the evening that you were able to observe.
She was talking to the Canadian couple mostly. She wasn't talking to her husband at all.
Okay, did there appear to be any tension between Mr. and Mrs. Menendez?
Objection irrelevant.
Sustained.
Was there anything unusual about their interaction that you remember now that occurred in front of the two boys?
Objection irrelevant.
Did you have something that you wanted to be heard about at the sidebar?
Yes, sir.
Okay.
Your Honor, I have no additional questions at this time.
All right, any cross-examination?
Could I ask just?
Oh, I'm sorry, sure.
Thank you. Mr. Lowe, you said this incident occurred in the spring of '89.
Around something like
Is
that.
that your best approximation?
Yes, it is.
All right. And when the comment was made and Mr. Menendez was pinching Eric, what was Lyle doing at that point when that took place?
You know, I really can't remember. I just noticed the pinch and I noticed the reaction of the young man. And I don't know.
And what was the reaction, if any, of Lyle Menendez right after this happened, if you saw him?
All right, did you see any reaction?
Not quite, not really. I think it was
Okay,
kind of
you've answered the question.
sorry, sir.
And after the incident took place, was there any visible reaction up to the point in time when you left by Lyle Menendez?
He seemed kind of sad. He seemed like it happened before. It seemed like he's
Move to strike seemed like it happened before, it's being pure speculation on the part of the court.
Objection sustained. That portion of the answer is stricken.
Did Lyle Menendez express surprise, like that was something out
No.
of the ordinary?
no.
That's all I have. Thank you.
Cross-examination.
Now, Mr. Lowe, you had never seen any of these people before that night, correct?
No, ma'am.
So you don't know what
Wait,
they're.
wait, yes or no? Had you ever
I'm
seen
sorry.
him before?
I'm sorry.
That's okay. It's not
No,
your
sir.
fault. It's
I'm
the way the
sorry.
question was
No,
asked.
sir.
All
No,
right,
you have not.
No, I have not.
Okay.
all right, so you don't know how these people behaved on any other night except for the night that you saw them, correct?
Yes, ma'am.
How was that you were contacted by the defense to testify in this case? Did you call someone or did someone call you?
I called somebody.
And when was it that you called someone in regards to being a witness in this case, Mr. Lowe?
I saw a tennis player on your court, and then after I saw the tennis player, then I realized the two boys we knew. We didn't know it. I didn't know it until then. And then Mamie called me, and then we talked on the phone, and then that's it. And then I felt very, very sad what happened at the table. I remember the whole incident, and she does too. And so that's what happened.
All right,
And
so then
So I called the attorney to let her know.
and you've been following the case on television?
Definitely not. The
Well-
only case I've seen is the tennis player. I don't know what is happening here.
All right, but it was seeing something on television that made you recall this event and contact the defense. Is that correct?
No, Mamie Van Doren told me before, a long time ago when it happened, but I didn't contact the whole thing until I felt with the tennis player he was on.
And you contacted the defense to be.
That's when I
witness.
did it, yes. Mhm.
And so now you say you're an entertainer, sir?
Yes, I have a talk show, a talk celebrity show.
Okay, and you're aware.
That's where I brought Mamie Van Doren that night. Go ahead.
And you're aware of the fact that this is being televised. Is that correct? Are you aware?
Overall,
Are you aware of the fact that these proceedings are being televised?
No, I do not.
Thank you.
I just know I've seen it on TV.
okay, anything else?
One question. Mr. Lowe, did you come forward because you wanted to be on television?
Definitely not. Definitely not. I'm on television every day. If you turn channel and cables, I'm on every day. So I don't need to be here. I thought I had something to say.
And you indicated that Ms. Van Doren contacted you at some point after the news of the Menendez parents' death occurred to remind you of this. Is that correct?
Certainly did.
And was it right after the news of the parents' deaths that she first contacted you about the incident?
Yes.
Excuse me. Okay, and the tennis player that you referred to, is that a witness who testified in this case?
Said yes?
Yes, yes.
All right. Thank you
I'm
very
sorry.
much. I have nothing further.
All right, thank you, sir. You're excused. Thank you. And the next witness would be a witness testifying before the Eric Menendez jury only. Is that right?
Yes, Your Honor.
Okay. As far as the Lyle Menendez jury is concerned, I'll excuse you until 11 o'clock and ask that you report back to your jury room at 11. Don't discuss this case with anyone. Don't form any final opinions about it. And if you return to the jury room at 11 o'clock, I'll give you more information shortly thereafter as far as our schedule is concerned. But we'll ask that you return at 11 o'clock. And are you ready with your next witness? Okay. Did you wish to call that next witness?
Well, I would prefer to have a short break before I call that next meeting.
Do you need a break? Okay. All right, let's take a break then and let council get organized here. And we'll have you all back at 20 minutes to the hour. Don't discuss the case with anyone or form any final opinions about it. We'll see you back here at 20 minutes to. The clerk indicates there's some matter before the next witness testifies.
777 to exclude a potential witness. That witness being Kathleen Cohen, who has testified already for the defense. Her daughter is proposed to testify at this juncture. I'm asking that this previous witness, Kathy Cohen, be excluded during Katie Whalen's testimony.
Your Honor, we object to that because the purpose of the exclusion orders here was not to shield people from hearing other people's testimony, since it's televised in its entirety. So I don't see any purpose for the exclusion order. Other witnesses, once they've testified, have been allowed to be in the courtroom. This whole testimony is going to take 10 minutes, and the mother would like to be here while her daughter testifies.
Do you intend to call Mrs. Cohen back?
She may be a witness.
Well, he doesn't
All right.
have any such intention, and I think it's a
Well,
ruse.
counsel, I don't see this as such a major issue. If the people indicate they intend possibly to call this witness back, then I'll have her leave the courtroom. It's not a big problem. And Mrs. Cohen, if you would just wait outside while the witness is testifying. All right, are we ready to proceed then?
Yes?
Okay, let's get the jury out.
They're going to stay here, right? Deputy Whalen?
The jurors are all back. You may call your next witness.
Katie Whalen, Your Honor.
All right.
Raise your right hand, please. You solemnly swear that the testimony you may give in the cause now attended before this court will be the truth, the whole truth, and nothing but the truth, so help you God. I do. Tell us your full name, spell your last.
Katharina Josephine Whalen, Whalen.
Could you spell your first name, please?
Catharina.
Do people call you Katie?
Yes,
Okay, Miss Whalen, are you related to Kevin Casey Whalen?
yes,
And are you related to Kathleen Cohen?
yes.
Who are they?
Mrs. Cohen is my mom and Casey Whalen is my brother.
And are you acquainted with Eric Menendez, my client?
Yes,
Do you recall a time in 1989 when Eric Menendez stayed at your home?
yes,
And was this following the death of his parents?
yes,
Do you remember the first night that Eric stayed at your home?
yes,
And do you recall whether or not you were at dinner with Eric that night?
yes,
And were you?
yes, I was there.
And who else was present at dinner?
My brother and my mom
And
and
yourself?
Eric and Eric and myself.
And do you recall where the dinner was?
We ate at La Paz. It's a Mexican restaurant in the valley.
And to the best of your knowledge, had Eric arrived in Los Angeles that day?
Yes,
Now, do you recall at dinner whether or not there was a conversation between Casey and Eric having to do with events of that day?
yes,
Overruled, the answer will stand.
Now, do you recall Eric talking?
yes.
And can you tell us what it was that Eric was talking about?
Objection to yourself.
Sustained.
Your Honor, this is not being offered for the truth.
Then it's irrelevant.
Well, I'd like to be heard.
All right, you may.
Thank you.
The court reverses its ruling and you may proceed with the question.
Thank you. I'd like to rephrase the question.
All right.
Ms. Whalen, you don't recall exactly what was said at the dinner, is that correct?
That is correct.
You recall, however, certain words that Eric said about the subject matter, in other words, of the conversation?
Yes.
And would you tell the jury what the words were that you recall?
Well, my brother and Eric were speaking. I recall.
Not your brother and you, what Eric had said at
Okay.
dinner.
There was mention of a will, and there was mention of Lyle, and the will having to do with a computer.
Okay. And that was the subject matter of the conversation that you overheard at dinner?
Yes.
Now, over the next few days, did Eric stay at your home?
Yes.
And specifically that, by the way, do you recall what night this dinner was, what day of the week?
I believe it was a Friday.
And did Eric sleep over at your house that Friday night?
Yes.
Did he sleep at your house that Saturday, the following Saturday?
Yes.
And the Sunday?
Yes.
And do you know if that was a holiday weekend?
It was, I think maybe it was Labor Day. I mean, the first weekend in September.
And do you recall if your brother left for school following that holiday weekend?
Yes.
And until the time that your brother left for school, do you recall whether or not Eric slept at your house each night?
Yes.
And did he?
Yes.
Now, after your brother left for school, do you recall a particular night when you were downstairs doing something with your stepdad?
Yes.
And would you tell us what were you doing?
We were just about to watch a movie, and I believe my mom wasn't home, and Eric was upstairs in my brother's room.
Okay. And when you say we were about to watch a movie, that was yourself and who else?
My stepfather.
That's Mr. Cohen.
Yes.
And did you do something after? Did you do something at that point?
Irrelevant.
Overruled.
You may answer.
I went upstairs and I knocked on the door to my brother's room, and there was no response. And I knocked again, and I said Eric, and there was no response. And so I opened the door.
And what did you see when you opened the door?
Eric was lying down on the bed, just like staring at the ceiling, almost asleep with his eyes open.
Did you say something to him?
Yeah, I called his name again.
And did he respond?
No, and I finally just touched the bed, and I think it shook him, and he just sat up and looked at me, and I asked him if he would like to watch the movie with us, and he said he was going to sleep.
When you saw him, though, in the bed, his eyes were open.
Mm-hmm.
How could you tell? Was the lights on in the room or off?
Yeah, there was a dim light in the corner of the room.
Now, some months later, did you become aware that Eric and his brother Lyle had been arrested?
Yes.
And do you recall a time when you accompanied your brother to the county jail to visit Eric?
Yes.
And do you have any idea about when that was?
My brother returned from Connecticut on May 21st, so I believe it was maybe the 25th or the before Memorial Day.
And did you go to the jail just with your brother?
Yes.
Did you meet anyone related to Eric when you got to the jail?
Yes, his grandmother.
And when you had your visit with Eric, was his grandmother close by?
Yes, she was standing. Lyle and Eric were next to each other, and she was standing near Lyle.
So both brothers were present for the visit time
Yes, at different windows.
at different windows
Yeah, like where you can speak.
to speak on a telephone?
Yes.
Did you visit with Lyle at all?
No.
And with respect to the visit with Eric, physically, how was it arranged for two people to visit one person at the jail?
Two people couldn't sit, but one person could sit and another person could stand. There was enough space for either myself to be sitting and Casey to be standing, or vice versa.
And for most of the visit, do you know if you were talking to Eric on the phone or was Casey?
Most of the time, Casey was speaking on the phone, sitting.
And were you standing right behind him?
Yes.
And could you hear what Casey was saying?
Yes.
And do you recall whether or not Casey was saying anything about any facts relating to this case?
I don't recall that he did.
Do you remember what he was talking about?
It was. I just remember asking Eric, him speaking to Eric about how Eric was and what it was like, and
What it was like in jail?
yes,
And did you speak to Eric briefly yourself over the phone?
yes,
And did you and Eric discuss any facts about his case?
no,
Do you recall at some point that your brother wrote a note?
yes.
And what did he do with the note after he wrote it?
I suppose he put it in his pocket. There was the glass, and he wrote it and just turned it around and put it on the glass.
Okay. I'd like to approach the witness, Your Honor, with Exhibit 215.
Yes.
Asking you to look at this piece of paper. Do you know if you've ever seen that piece of paper before?
Yes,
Where have you seen it?
at the jail, and the other night when my brother was cleaning out his drawers and we found it.
And was it crumpled up inside your brother's drawer?
No, he was cleaning, and we looked at it, and it was kind of ironic because he was home to stand on to come to trial, and he just threw it away. And then when we remembered it, and we decided that it was important to bring.
You say he threw it away.
I believe he crumpled it and just put it in his bedroom in a trash can.
Okay, and then he retrieved it from there?
Yes.
It had been in his drawer?
Yes, it was in his drawer for 3 years.
Now, during the time, did Eric remain at your home and spend nights at your home after your brother went back to school?
Yes.
And during the time that Eric was at your home, did you ever receive any phone calls, someone asking for Eric?
Yes.
And did you recognize the voice in the phone calls?
No.
Was it male or female?
Male.
And did that person identify himself in any way as a relative of Eric's?
No.
And did the person merely ask if Eric was there?
Yes.
And do you recall if these calls came in on the line you shared with your brother or on your parents' line?
I believe it was the line I share with Casey.
And would you give us the last 4 digits of that line?
0313.
I have nothing further now.
Cross-examination.
Ms. Whalen, did you testify that your brother crumpled up this sheet of paper the night before he came in to testify?
I don't think it was the night before.
When was that you saw this piece of paper?
He had come home in August because he thought he was going to have to be on trial then, and right before he left to go back to school, he cleaned it out then, and then he returned a week later to come.
So August when?
Maybe the 16th or 17th.
And is that when he was cleaning out his room?
I think so.
And were you with him cleaning out the room?
Just for a minute, I came upstairs to ask him something, and I saw what he was doing.
At that time, did you see this letter?
Yes.
And did you have a discussion with your brother about this letter at that time, August 16th?
Yeah, he opened it and said, oh my gosh, this is from when we went to the jail, and I looked at it and I agreed with him, and it didn't seem to serve a purpose for anything, so he threw it out.
Okay, so on August 16th, he crumpled it up and threw it out?
I believe so.
Okay.
I don't know if it was August 16th for sure, but
That's the best
yes.
recollection is that he threw it out on the 16th of August. And did you help him clean up that day?
I went through one drawer.
And he was going through his other drawers.
Yeah, he has a desk and a dresser, and
Did he throw away some other things that day?
yeah, some letters from people, and
And just tossed them in the wastebasket?
to the best of my recollection, yes,
Okay.
or a trash bag.
Now, do you remember the specific date that Eric Menendez, the defendant in this case, came to your house after the murders of his parents?
I believe it was September 1st.
How do you remember that specific date?
Because I look back and I had a calendar that said when I worked. I just started a job then at the end of the summer of 1989. And on September 1st, I worked from 6 to 9, and they picked me up at work.
6 to 9 at night?
Yeah, I believe.
And who picked you up from work?
Well, my mom and my brother and Eric were in the car.
And where were you working at that point?
Calabasas Yogurt and Video.
And after they picked you up, the three of them, you then went to dinner?
Yes.
Did you check your records to see if you had been working on August 31st?
Yes, and I hadn't, because I had gotten the job on the 27th or the 28th of August, and that was my first day working.
Did you have a car at that time?
No,
Which car did they come in to pick you up?
my mom's car.
Did Eric Menendez have a car?
With him at that time?
Yes.
Not when they picked me up, because I live like 5 miles away from where I worked, so they didn't need 2 cars.
On that night, did you see Eric Menendez's car?
I do not remember.
Okay, do you remember seeing his car at any point during his stay at your house?
Oh, yes, for sure.
But you don't remember whether he had it on that particular night?
I don't believe he had it there that night, but when we got home, it was dark. So I don't know. I don't think it was there, but I don't remember.
Now, you testified as to some phone calls that were made to your house on the 0313 number.
Mhm.
Eric Menendez was a good friend of your brother's, wasn't he?
Yes.
And you had received calls from Eric Menendez at that number previously, had you not?
Yes.
And you had taken calls because it was your number as well,
Mhm.
and he would ask for Casey.
Yes.
And during the period of time when he stayed at your house after the murders, did you receive some calls on your line
Objection, Your Honor, vague.
From who?
from Eric Menendez?
You can ask the question.
Um,
You understand the question?
yes. You want to know if he called my
Yes.
house? I don't recall if he called my house while he was staying at my house.
Okay, during a period of time from September through March of
Mhm.
1990, prior to the defendant being arrested,
Mhm.
did you receive any calls from him at that number?
I don't know. I don't remember. I don't believe that anyone would call if Casey wasn't there. Casey was at Santa Barbara
Until when?
until he left after Christmas of his first semester there and went to Connecticut. So I don't think Eric would be calling my house while Casey was away necessarily.
Was the defendant a friend of yours as well?
No, I wouldn't say we became friends on our own. I became friends with him because he was friends with my brother.
Did your brother come back to visit your family in March of 1990?
In March, I think he left in the end of January for Connecticut and drove across country in May. I don't recall him being there at spring break.
Now, in May, he came home.
Mhm.
Casey Whalen came home, is that correct?
Yes.
And it was during May that you and your brother went to see Eric Menendez at the jail.
Yes.
And do you remember what day that was?
I believe it had to be after May 21st
And why do you say that?
because Casey got home on May 21st.
Do you remember what sort of notebook your brother had with him on the date that you and your brother went to see Eric Menendez in jail?
Objection, Your Honor, since facts, not in evidence.
Rephrase the question, please.
Yeah. Do you remember whether or not your brother had a notebook with him, with a pen, on the date that you and your brother went to visit Eric Menendez?
I don't believe he had a notebook with him.
What did he have with him?
His driver's license, car keys. I don't remember him having any objects in his hand.
Okay.
Since
Did you have any objects in your hand?
No, the parking garage ticket in my pocket. I didn't have it in my hand. I mean,
Now, when your brother wrote a note that he wanted to keep secret, and he put the note up on the glass to
Mhm.
show to Eric Menendez, where did he get the paper?
I don't know. There was people next to us on either side. I believe he borrowed it from someone next to him.
Did he have to borrow a pen as well?
Yes.
Do you know who that person was next to him?
No. I believe the grandmother was talking to Lyle and someone else. I don't recall who was talking to Lyle. And I don't know who was to our right.
So Lyle and Eric Menendez were side by side while you visited with Eric Menendez.
Mhm.
Is that yes?
Yes. Sorry.
And the grandmother was talking to Lyle while you and your brother were talking to Eric Menendez? Is
Yes.
that right? Now, you've testified that Eric Menendez slept over your house every night that he was there from when he first arrived until he left about a week after Casey left for school. Is that correct?
Objection, Your Honor, misstates the testimony.
Rephrase the question, please.
Well, why don't you tell us? Did Eric Menendez sleep over your house every night from the first night that he arrived?
I believe he stayed there every night that he was at my house, but I didn't check his bed at night.
So you don't know where he was every single night. Would that be fair to say?
Most nights I recall him being at my house, but I can't say that he was what time he slept or.
Now, you've testified on direct examination that he slept Friday night, Saturday night, Sunday night, Monday night
Mhm.
until Casey
Left on Tuesday.
Now, that wasn't quite right. There were nights that you didn't know whether he was there. Is that fair to say?
Objection argumentative.
Rephrase the question.
Would it be fair to say that you really don't know whether he was there every night?
Well, the question I answered that he stayed there almost every night the whole time he was there. He was there for a few days after Casey left. And after Casey left, I wasn't watching after him. I mean, my brother wasn't around to be with Eric.
You had to watch after Eric Menendez?
No, I'm saying we were not watching after him.
Okay, he can come and go as he pleased, correct? He was an adult,
Right.
and he would go out and take his car out and do whatever he wanted to do, and Casey would do likewise as with his own friends. Is that fair to say?
Yes.
And you were working yourself, and you weren't watching what Eric Menendez was doing, were you?
I only worked that Friday of September 1st. And I don't think I worked the other days that my brother was home.
Okay, but fair to say that you have your own friends and you weren't babysitting Eric Menendez.
Yes.
Do you recall receiving any phone calls from Eric Menendez from May of 1990 to the present on your 0313 number?
From jail?
Yes.
Not that I recall. I left for boarding school, though, in July of 1990, so I wasn't there for a good portion of the time.
Have you been out of the house continuously since July of 1990?
Yes, I just graduated in June of 93, and I was home summers and all vacations.
Well, during the summers, since this May of 1990, that you were actually home, you still had that number, that 031?
No, it was cut off when I left for boarding school because Casey had left for school, and then when he returned, he just used my parents' line.
Okay.
I think it might have been done right when I left for boarding school, but sometime around July of 1990.
What are the last four digits of the main line to the house?
Your Honor, at this point, I'm going to object that this is beyond the scope.
0160.
Thank you. I have nothing further at this time, Your Honor.
Just a couple of things. Ms. Whalen, are you certain that at least during the beginning of Eric's stay with your family, before your brother left for school, Eric indeed slept at your house each night?
Yes, I'm most certain.
And are you less certain that he slept at your house each and every night after Casey went to Santa Barbara?
Yes.
Could there have been a night or two that he didn't sleep at your house after Casey left for Santa Barbara?
It is possible.
Now, the other thing is, I'm trying to understand what happened to the note after it was put in the trash so that we still have it and it didn't wind up at the dump.
Well, Casey had only been gone a week, and he had left the trash basket in his room.
I see. So he then retrieved it.
Yes.
And it was the same note that you had recalled from the jail.
Yeah.
Did you see your brother write a new note to produce it in court?
No.
Was your mother present when he in the house when he retrieved the note?
I believe we were all downstairs, and he got it upstairs.
And isn't it true that when he went and retrieved the note, I was on the
Objection.
telephone.
This is leading, Your Honor.
Was I on the telephone with you and members of your family when Casey went looking for the note?
Yes.
And did you overhear Casey saying something to me about he might still have a note?
Objection calls for hearsay.
Yes.
And did he then hand the phone to someone else and go upstairs?
Yes.
And did you then see him come downstairs?
Yes.
And did you see the note in his hand?
Yes.
I've nothing.
Ms. Whalen, when Your brother put the note up on the glass. You didn't see the note, did you?
No.
He put it away from you.
Yes, Eric couldn't see it.
So you can't testify as to what he put up there that day, can you?
Well, yes, because the note was sitting down on the. I saw him writing.
You saw him write the note?
It's a small glass area. It's smaller than this, and he was in a chair, and I was standing right next to him, over him. So, there's nothing else that he wrote.
When he put this note up on the window, how did Eric Menendez respond to him?
I don't recall that it was any. I mean, do you want what he said exactly?
Yes, you saw your brother write this note, supposedly. You saw your brother put this note up on the glass.
Mm-hmm.
I suppose you're interested to see how Eric Menendez responded?
Objection, Your Honor, argumentative.
Overruled.
I believe Eric said. I believe he said.
But Your Honor, I'm not sure the witness has personal knowledge of what.
I don't recall exactly what he said. He was on a phone, so I would have to have read his lips.
Well, I would object to liberating at this point.
All right, your next question, please.
Did he do anything physically? Did he shrug his shoulders, or did he nod his head? Did he do anything of that nature?
I think he kind of shrugged his shoulders, but I don't believe it was anything outstanding. I don't recall his reaction being anything of memory.
Now, you've talked to both your brother and your mother about the events that occurred when Eric stayed at your house back in late August, early September of 1989, correct?
Yes.
And you've discussed that over the weekend?
No, Casey left on Friday.
You discussed it with your brother last week when he testified over the 2 days?
I believe, yes.
In fact, you came to the courthouse with him, correct?
Yes.
And you were with your mother as well.
Yes.
And you've had discussions with your brother about what occurred during that period of time, is that correct?
Yes.
Discuss the case?
We discussed what happened.
What do you mean by that?
Your Honor, I'm going to object to this one is beyond the scope of redirect.
Overruled.
We discussed what happened when Eric was there at our house.
And were there things that you filled in and things that the other members of your family filled in that you couldn't remember?
I actually have the best memory out of everyone, and I remembered where we ate dinner. I remembered most things.
Do you remember ever going out to dinner with Eric Menendez and your mother and Casey during any of those other days that Eric Menendez spent at your house during that period of time?
No,
Never went to dinner again?
I don't recall us all four of us being out together again.
What happened the next day?
Your Honor, I'm going to object. This is beyond the scope of redirect.
Sustained.
Your Honor, may we approach? Thank you. First night you had indicated that Eric Menendez stayed over at your house, that you went to dinner, correct?
Yes.
And it was with two other members of your family.
Yes.
Did you come home to your house after dinner?
I believe so. Yes.
You believe so?
I don't recall going anywhere else besides home.
Okay. That night, did your brother or Eric Menendez go anywhere?
Not to my knowledge.
You don't recall?
No.
The next night or the next day, what do you remember about that day?
I believe. I don't recall. I don't recall anything specific about that day.
The next day after that, what do you recall?
Nothing.
How about the following day?
I believe that we went and did things to get my brother ready for school.
When you say we did things, who are you referring to?
My mom and I and my brother.
And Eric Menendez was not with you.
I don't recall.
And the next day, what happened?
I believe that was Tuesday and Casey left.
Okay, you remember that.
Mm-hmm. Well, yes.
That's yes? After Casey left, what do you remember about Eric Menendez being at your house?
I remember during the days he played tennis. I remember one day specifically when he had just gotten back from playing tennis.
Was that the day after Casey left?
It could have been. It could have been the following day.
All right, the next day. This is 2 days after Casey left. What happened?
I don't recall for sure.
All
I
right.
don't. I didn't.
And the third day?
No.
And the fourth?
No.
The fifth?
I don't. I mean, it was 4 years ago. I don't remember exactly what I did.
Do you remember what Eric Menendez was doing during that period of time?
I don't know what he did every minute of the day. No.
Is your memory pretty vague as to what occurred during that period of time?
I assume so, but I didn't stop to write it down, what I was doing.
Now, during this period of time, did you see Craig Signorelli?
Objection, Your Honor, beyond the scope.
No.
Did you never saw him at your house?
No. Not while I was home.
And you were home most of the time?
No, not necessarily. I recall my mother telling me that he'd come by, but I did not see him myself.
I have nothing further at this time.
No, Your Honor. Can't see the one.
Douglas Herbert Doss. Last name is Doss.
Why don't you sit here so you can see me?
Herbert.
Mr. Doss, what is your occupation?
I'm the director of tennis at Mountain Gate Country Club.
You're whispering. I can hardly hear
Oh,
you.
sorry. I'm the director of tennis at Mountain Gate Country Club.
And Mountain Gate Country Club is here in Los Angeles
Yes, it
County?
is.
And being director of tennis, does that mean that you're basically a tennis expert, tennis pro, tennis coach?
Yeah.
And how long have you been involved in that sort of capacity with tennis?
About 20 years.
Now, several years ago, did you make the acquaintance of Eric Menendez and his family?
Yes, I did.
At the time you made their acquaintance, where were you employed?
The Calabasas Park Tennis Club.
And what was your position at Calabasas Park Tennis Club?
I was the manager and director of tennis, head pro.
And do you remember approximately what year it was when you first made the acquaintance of Eric and his family?
Not exactly, 87 maybe. I don't really recall exactly the year.
When did you start at the Calabasas Park Tennis Club?
So I worked for Warner Center Club. We took over Calabasas in 84, I believe it was, for 4 years.
Okay.
I ran two clubs at the same time.
Warner Center was another tennis club in the San Fernando Valley?
Yes,
That one's off Canoga.
right, in Woodland Hills.
Now, do you know if the Menendez family belonged to, strike that, at some point, did the Menendez family join the Calabasas Park Tennis Club?
Yes, they did.
Did that also give them privileges at the Warner Center Club? or-
Yes,
Okay.
yes.
Now, when you worked at Calabasas Park Tennis Club, was there a group of youngsters that you were coaching?
Yeah, there was quite a few kids there at the time.
And by kids, what age group were you mainly concerned with?
12 to 16, 12 to 17.
And were there a group of kids who were from Calabasas High School who also belonged or were members of the club?
Yes.
And when you met Eric Menendez, was he attending Calabasas High School?
Yeah, he was just moving into the area and just starting school.
If I were to tell you that the family moved into the area in the summer, fall of 1986, would that refresh your recollection about when you met them?
Yeah, sure, definitely.
And it was just when they had come to the area?
Right, right.
Now, this group of, let's focus on where there are a certain group of kids who are at Calabasas Park Tennis Club who were high schoolers.
Yes,
And is that the group that Eric eventually became a member of?
right.
And how would you compare Eric, as far as his behavior and personality, to the other members of that high school age group? Did Eric stand out somehow in your notice?
When he first came to the club,
Well, after you got to know him, I would.
he was fairly calm. I mean, compared to a lot of the other kids that were how do you say, much wilder than normal kids, you know. But he was pretty calm guy.
When you say these other kids were wilder than normal kids, were they good kids? I mean,
Oh, they're basically good kids.
did you notice in the course, first of all, did you coach Eric?
Yes.
Did you teach him?
Yeah.
Over how long a period of time?
Well, privately, a very short time, but he was in the junior program itself for a couple of years.
So you knew him and had contact with him over a period of a couple of years, say from 86 to 88?
Right.
And at some point did he start, well, at some point did he just leave Calabasas Park Tennis Club?
Yes.
And to the best of your recollection, that would have been 88?
Yeah.
Did he also receive private coaching from other coaches that you were aware of?
Yes.
Now, in the course of your acquaintance with Eric, did he ever demonstrate any aggressiveness towards authority figures?
Not aggressiveness, no, huh?
Well, that's what I'm asking.
Yeah, no, never. No, not hostile at all.
What did he exhibit towards authority figures, such as you were an authority figure
Yeah,
at that club?
Yeah. We got along fairly well. He had a great sense of humor. He worked really hard, extremely hard, and at times he'd just space out during lessons and such. But
We'll get to that. But he worked hard.
Yeah.
Was he obedient, respectful to
Oh,
orders?
definitely. Yeah, he was.
Sustain the answer, Stan.
Well, Your Honor, I'd like to be heard.
Counsel, let's move on to something else.
Was there something you observed about Eric that seemed unusual or abnormal during the course of workouts?
Objection, David,
Understand what she's asking?
Yeah.
Okay, overall.
Okay. Did you observe something that seemed very unusual to you?
Yes, I did.
Okay, and if you could, speaking slowly, describe for us
Okay.
what this was that you would observe.
Okay. As I said before, Eric was a very hard worker on the court, and he'd basically do everything he was asked to do. And but there were times when he would just disappear mentally. He'd just space out, and he'd be gone for a second, and then he'd start laughing about it. And I just assumed that was his sense of humor, because that's where we connected more than anything else, is that level of humor that he had. But he would just be gone. And for no real apparent reason. It wasn't like it was real stressful, or it was something I was asking him to do that he wasn't capable of doing. It would just be a time where I wouldn't expect it, and he'd be gone.
He just seemed to, his concentration would seem to evaporate?
It was over. And it wouldn't last very long, just very short periods of time. And then we'd take a break and talk about it or whatever, but it wasn't,
Now,
wasn't expected.
sometimes when you're working with kids, with teenagers, and you're pushing them, do they sort of stop working or break concentration in a deliberate way?
Some kids will, because they don't want to do it. But I mean, most kids at
Go ahead.
at that level of workout will stay with you, and you can tell when they've had enough. You can tell when they're about ready to, to break or need a break. And
These things that you noticed with Eric, though, was it what you had seen with any other kid?
objection irrelevant.
Sustain.
What was different about what you saw with Eric?
Objection irrelevant.
Sustain.
Well, Your Honor, I'm trying to get
He's
some.
described how he observed this incident. That's sufficient.
Would Eric be able to tell you afterwards what had gone on mentally in his head that caused him to space out?
Objection calls for hearsay.
Overall.
no.
I mean, was there a discussion about it where you'd want to know?
I would try to get to find out, but he wouldn't even know, actually. It was more of a,
Objection, speculation as to what.
Sustain that answer, straight.
Did he indicate to you that he didn't know?
that's what it was. Yeah, he didn't know.
Now, did you ever observe Eric's father at the Calabasas Park Tennis Club?
Yes.
And specifically, did you observe an incident that involving Mr. Menendez, Eric, and his brother Lyle?
Yes.
And did you see Lyle from time to time?
Occasionally when he was in town, yeah.
And could you tell us, with respect to this one incident, what preceded the noticeable aspects of the incident? What was happening?
Eric and Lyle were working out on the front stadium court at Calabasas.
When you say they were working out, what were they doing?
They were hitting with each other, working on their game.
They were hitting balls at each other?
Yeah.
And what occurred?
Mr. Menendez was leaning over the railing. Mr. Menendez was leaning over the railing.
Had he been there, Mr. Menendez, had he been there all the time?
No.
You got to let me finish.
I'm sorry.
That the two sons were working out?
No.
Did you see him show up?
Yeah, he showed up in his work clothes, business suit.
He was wearing a suit?
Yeah, without a coat.
Okay. And when he showed up, he went over to this court that his sons were playing on.
Right at the end of the railing.
And what did you observe?
A couple things. One, that he started like basically yelling at the kids to hit harder, to work harder. And they had been doing that before he arrived.
They were doing what before he arrived?
They were working hard before he arrived, which they always did when they hit with each other. But it changed when he showed up. And because of his demands on them, they they were hitting the ball harder, and they always hit it hard anyway. But it changed because it was more it looked like they were mad when they were playing.
Okay.
And
He was demanding that they hit the balls harder and
hard
harder.
as they could.
And they
and-
started hitting harder and harder
Yeah.
and harder.
Yeah.
Okay. And did he sound satisfied with
No,
it? What did you hear?
he didn't change his tone. He kept asking for more. So
And was he addressing his demands more towards one of his sons than the other?
a little more towards Eric, just because Lyle was stronger. But
And-
it was towards both of them.
Okay. You had observed, even prior to this incident, the relative strengths and talent of Lyle as a tennis player and Eric as a tennis player. And how would you compare them very briefly?
Objection, rebuttal.
Sustained.
Was Lyle physically stronger and a stronger athlete than Eric?
Objection, no.
Overall.
Yes, he was.
In your opinion, as a tennis coach, was it reasonable for someone to expect Eric to be able to perform at the same level as Lyle at that time?
Objection calls for speculation.
Overall.
No,
No, it was not reasonable?
it was not reasonable.
Did Mr. Menendez, when he was making these demands, how did he appear mood-wise? Was he happy, sad, angry, what?
He definitely wasn't happy. I don't know if it was anger, but he was not pleased with what he was seeing.
And did you see anything to criticize in what the sons were doing in response to his demands?
Objection, rebuttal.
Sustained.
As a tennis coach, was there anything that they were doing that was wrong vis-a-vis his demands?
Not before he showed up. When he was there, yeah.
Well,
He was for what he wanted them to do. It didn't make sense. I mean, you don't do the things. You don't hit the ball 1,000 miles an hour all the time, and that's what he wanted from his kids.
of course, they were trying to do what he wanted,
Of course, they were.
and he was not pleased.
No,
So could you figure out any reason why he was not happy with them obeying his instructions?
Objection calls for speculation.
Sustained.
Now, did you hear Mr. Menendez say critical things besides the demands? Was he saying berating or critical things to either of his sons?
I don't recall the exact words, but that was the tone of it.
Now, were you also acquainted through the Calabasas Tennis Club with a young man named Craig Signorelli?
Yes, I was.
And were you aware that Craig and Eric knew each other?
Yes.
And do you recall at some point after Eric and Lyle were arrested, being at the pro shop at Warner Center Club and hearing a conversation of Craig Signorelli's?
He was actually in the workout facility at Warner.
It was at the workout
Yeah.
at the Warner Club.
Right.
And was Craig Signorelli in that workout facility?
Yes, he was.
And did you overhear him talking?
No, he was talking to me.
So he was talking to you directly?
Yeah.
And can you describe what his tone was when he was talking to you? What his demeanor was?
It was gloating, maybe. I don't know what he was telling me a story, and he was very proud about it, that he was involved in the story he was telling me.
And he was telling you of his involvement in what?
In the Menendez situation at the time.
And did he say anything to you about his expectations or any expectations he had because of his involvement?
That was the gist of the conversation about him, book deals and movie deals, that type of thing, that he knew the facts and that, he was bragging about it.
What was he saying about book deals?
Well, there was a book in this for him. He was going to write a book about it.
And what was that going to do for him?
I don't know, fame and money. Who knows? I mean, but that's what he was talking about.
Did he say that he was going to make a lot of money from what he knew?
Yeah.
And how did you respond to him?
I told him he should keep his mouth shut because the facts weren't out. And he said, well, they are. I know the facts. He proceeded to tell me the facts. I'm going, well, we don't know that. And this was in a room of people, that the people were working out. Anybody could hear this. And I told him he just should be quiet.
And did he seem to enjoy talking about this in front of all these other people?
Yeah. It wasn't like a quiet conversation.
It was a boastful conversation.
A bit, yeah.
Now, Mr. Doss, do you recall myself and my private investigator, Miss Erdely, interviewing you in July of 1992
Yes.
up at the Mountain Gate Country Club?
Mhm.
And do you recall at that time we gave you for you to review a police report purporting to contain a statement from you to Detective Zoller, I suppose it is.
Yes.
And did you review that police report in July when I first showed it to you?
I did.
Yes.
Anyway, back to July of 92, did you read it? I think it's like a 2-paragraph statement of yours in this police report.
Yes.
And did that 2 paragraphs in this report accurately reflect what you had told the Beverly Hills Police Department?
Not exactly, no.
And for example, had you told the Beverly Hills Police Department that Eric was a wild kid, very high strung?
No.
What had you told them about Eric's temperament and personality?
That, well, exactly the exact words I'm not sure, but because it's been a while. But that wildness wasn't like the other kids that were at that club at the time. It was more like a young lion just kind of expressing himself and finding out what his boundaries were, but not. It wasn't negative. It wasn't like he was obnoxious and pushy like a lot of the kids were, without any discipline.
Okay. So did Eric appear to have discipline?
Oh, yes, he did.
Did he appear to be hardworking and obedient?
Yes.
And even as to these other kids who were wilder, did they all turn out okay?
Yeah, they did, actually. Even the wildest ones.
Okay. Now, did you tell the Beverly Hills Police in your interview, I believe this interview was August 29th, 1989, that Eric's father was very interested in his tennis game and would always make sure that he concentrated on his game?
No.
What did you tell them about Jose Menendez and his attitude towards his son and his tennis?
What I told him was I thought that he was overbearing and basically living through his kids like a lot of, parents do in sport. And it wasn't realistic. But not that he was attentive and all that.
Attentive sounds positive.
Yes.
Did you think Mr. Menendez's involvement in his son's sports was positive?
No, I did not.
Speculation, no proper opinion.
Okay, I have nothing further. Thank you, Mr. Dawson.
How long the cross-examination? Maybe 10 minutes.
Thank you, Your Honor. Sir, you had indicated that you had actually coached Eric Menendez for a short period of time over this 2-year period.
Yes.
Was a coach by the name of Craig Heinberg the coach?
Yes, he was.
And how long was Craig Heinberg the coach?
I don't know that. I don't know how long he coached him because I know that a gentleman named Paul Hobach coached him as well.
Okay.
So I don't know how long Craig was involved with that.
Do you know Craig Heinberg?
Yes, I do.
And how do you know him?
Through tennis.
I'm sorry. How was that?
Through tennis. I mean, he was at the Calabasas Tennis Club when we took over the club.
Okay, and
He was teaching there.
So you were the manager and he was one of your coaches?
Mhm.
Is that a yes?
Yes.
And he was the one that was given the task of coaching Eric Menendez?
I don't know if he was given the task. I know that he was coaching a lot of the kids at that time, along with some of the other pros that were there as well. I don't know how long that was with Eric.
Now, you remember talking to the detectives from the Beverly Hills Police Department on August 29th, 1989?
Yes,
And you told the detectives at that time about the coach, Craig Heinberg. Isn't that correct?
I believe so. I believe I did.
And
I don't recall that.
I would object on that because it's in the report.
at some point, did you tell the detectives about Coach Craig Heinberg?
Yes,
And you've testified here that Eric Menendez, you had said that he was a wild kid in the report, but you said he wasn't wilder than some of the other.
it wasn't wild in a negative sense. I wasn't saying that he was out of control and that type of thing. It wasn't a negative statement towards it.
And you were asked about your association with Eric Menendez over these 2 years from, I believe, 1986 to 1988. And you said that Eric was not hostile, not aggressive. Is that correct?
I believe so. Yes.
And this is what you knew about him over that 2 year period?
Right. My experience with him.
Okay. You knew that Craig Heinberg, the coach, had problems with Eric Menendez.
Objection, Your Honor, calls for hearsay. Well, I'd like to approach on this whole.
Isn't that correct, sir?
I had heard, yes, he had problems with him.
What had you heard?
Your Honor, I'm objecting. This calls for hearsay. They can call Mr. Heinberg if they want to.
Counsel, let's not argue the matter. Overruled.
What had you heard about the incidents between Eric Menendez?
I had heard that he had trouble with him disciplinary wise.
That who had trouble
That
with him?
Craig had trouble with Eric.
Craig Heinberg.
Yes.
And what in particular did you hear about that?
Objection, hearsay.
Sustained as to specifics.
Were you given any information about the breaking into?
Objection, Your Honor, and I'd ask to approach, and I'd cite the conduct.
All right, we'll hear your discussion at the sidebar, and the jury is admonished to disregard the remarks of counsel. Lawyers can say things, but when they say things, they're addressing me and they're not addressing the jury. When the lawyers address the jury, they'll do that in closing argument when they have a chance to comment on the evidence. Discussions at this point are directed towards the court. All right, let's see counsel at the sidebar.
We were talking about this coach, Craig Heinberg. When you spoke to the police on August 29th, 1989, had you been given information from Craig Heinberg about his relationship with the defendant in this case?
I don't know if it was directly from Craig, but
I'm going to object, Your Honor, for any further answers.
All
Calling for
right,
hearsay.
did you understand the question?
yes, I did.
Okay, and it's either yes or no.
No,
Okay.
You had not received information directly from Mr. Heinberg?
no.
Had you gotten information regarding the relationship between Mr. Heinberg and the defendant in this case, however?
Objection, Your Honor, calls for hearsay.
Overruled.
Yes.
Okay, thank you. No further questions.
Can you redirect?
Your Honor.
All right, thank you. You may step down. Your excuse subject to being recalled.
Thank you.
All right, and let's get the gold jury in as well, please, and the other parties. Both juries are back in court, and I've just been conferring with counsel. I know the gold jury especially has not been in the courtroom very long for testimony today, and I've been conferring with counsel regarding the scheduling here. There are matters that the lawyers and I will be discussing this afternoon, and it's going to, from what they tell me, it could very well spill over into tomorrow, at least to some extent, regarding discussions that they and I will have here regarding issues that will relate to the next evidence in the case. So to give us all sufficient time to discuss those matters, what I'm going to do is excuse you for the balance of today and also for tomorrow, because as it's developed, it's going to require some time tomorrow, I think, as well, to deal with these matters. And then when we start up again on Friday, my expectation is, unless something highly unusual occurs, my expectation is that we shouldn't have as many delays as we've had in the last week or so. Some have been for personal reasons that I've explained to you that have occurred and were unavoidable situations involving counsel and their situations. And there's nothing obviously that could be done about that. But we are now getting to the point where I think we're going to start seeing evidence without much interruptions. And that will be starting Friday. So what I'm going to do is ask that you all return on Friday at 9 o'clock. Don't discuss this case among yourselves or with anyone else. Don't form any opinions about it. Don't look at any news coverage. Don't permit yourselves to be exposed to anything about this case outside of the courtroom. And on Friday morning, when everyone is present, we'll resume with the trial. And we'll see all jurors back here, both juries, Friday morning at 9 o'clock. All right, we'll see counsel. Counsel remain just for a moment. All right, before we take our break for the lunch hour, the defense indicated yesterday, at least the defendant, Eric Menendez counsel, that there was some document to be filed today. Let me see it. Oh, that was just your document. I'm talking about something that was going to be filed by counsel in relationship to other matters. I received the document filed by Eric Menendez counsel. But there was, you indicated that there was an extensive brief in the works that was going to be filed this morning on the subject of testimony of the defendants, and that has not been filed.
I had gotten that impression prior to the weekend from Ms. Lansing that Mr. Burt was working on that, but Mr. Burt was not in town over the weekend, so I thought that that's what he was working on. I was surprised this morning when he didn't file it.
Okay, hold on. Let's get the teacher out. All right. Is there going to be something filed? I'm not asking that you file something. I just want to know if you have something. I'd like to have a chance to review it before you.
The last time we were in court, we had not discussed that with the court, but looking at some of the issues over the weekend, it appears that there are 402 issues regarding cross-examination, but they're really not law. They're really more fact-specific issues, and the court is, I think, pretty familiar with the law because we discussed it in relation to Dr. Oziel and cross-examination concerning collateral matters. So we're prepared to enumerate for the court once again that the areas that we have concerns about, but I don't really think unless the court would like further briefing that it's really a. No, I'm not inviting it. The court needs further argument.
All right. If you have a list of things that you feel have to be addressed prior to the testimony of the witness, you may supply that to the court. You can do that. Counsel at the sidebar here indicated that they felt that this hearing could take more than just the balance of this afternoon. That's why we set aside some time tomorrow as well to complete it, and whatever is left tomorrow, if any time, counsel can use to prepare Eric or Lyle Menendez's testimony. But the reason we've set aside this time was to permit both sides adequate opportunity to be heard. There was some suggestion that there is a need to address the examination of Eric Menendez as well prior to the testimony of Lyle Menendez. I don't know if that is necessary, but I'll certainly hear the parties in that regard. But we'll resume at 1:30 and we'll hear, but at that time, I want counsel to present to the court a list of those things that you feel have to be addressed. All right, we'll be in recess until 1:30. The court is in receipt of 3 lists prepared by the prosecution. I assume counsel have seen that as well. Oh, okay. It was indicated to me it was handed to the clerk by Mrs. Bozanic, so I assume So,
We hired
who is the
her.
author who wants to claim credit for this? Anybody?
I wrote it.
You don't want to claim credit, though.
Well, no, well, it was a joint decision. We had a committee meeting, and I was appointed secretary. So it's my handwriting.
All right.
But I have no thoughts of making
No comment.
no comment.
All right. Also, the defendant, Eric Menendez, filed another document this morning, which details evidence that has been or potentially could be introduced in regards to Lyle Menendez. Before we get into all the minutia that is contained in these documents, let me again explore with the parties your positions on the matter of one defendant testifying in the trial before the other defendant's jury. I know we've heard the position stated yesterday by the prosecution and defendant Eric Menendez, but the defendant Lyle Menendez has not expressed a view on that subject.
It would be our intention to call Lyle Menendez just in front of our jury, and we will be objecting to Lyle Menendez testifying in front of our jury. And similarly, we would be objecting to Eric Menendez.
I'm sorry, go ahead. You would be objecting to Lyle Menendez testifying where?
In front of Eric Menendez's jury, and we would also be objecting to testimony by Eric Menendez in front of our jury.
Okay, well, let's explore it one step at a time then. What is the reason why you would object to your client testifying before another jury?
I think that's Eric Menendez's objection, really, but our basic position is that the co-defendant is not at this time calling Lyle Menendez in its case in chief. And because of the position of the co-defendant, it seems that the prosecution is in effect having the benefit of joining the direct examination of our client to the detriment of Eric Menendez, in a situation where if we were in separate trials, that could never happen.
Okay, but again, that has nothing to do with your case per se.
No, I think, as I said, I think it's an objection of Eric Menendez.
Okay, that's what I asked. You have no objection to your client testifying before the Eric Menendez jury or the jury in the trial next door or anybody else. Would that be a fair statement?
Well, only to the extent that we would have any standing to assert Eric Menendez's right.
Which you don't.
Which we don't, so I think we're in the position of leaving that objection to the co-defendant.
Okay, so the only objection you have is to the other defendants testifying before your jury.
Let me just suggest something. We just discussed this, and I think the problem for both of us in having our clients testify in front of the other jury is this. We anticipate that there will still be some areas where our clients would not be testifying in front of the other jury because of 352, 1101 type issues. And to the extent that that happens, it makes it very difficult for us to put on our clients and have them leapfrog over and jump around and hide under the bushes and back off of and not deal with certain things because certain things can't be heard by both juries and then have to go back before our own jury to deal with those things. Much more so than with some of the other witnesses, since we anticipate that they'll be on the stand 4 or 5 days apiece.
They being the defendants.
The defendants, it will be very difficult to try to carve out from them if you're trying to put on a coherent body of evidence. It would be very difficult to jump away from or avoid or have to skip around areas, and some of them are very big areas with respect certainly to the evidence that is coming in the record in this case, you gathered just will make it very difficult to examine him in front of the Lyle Menendez jury on direct even. if some of these areas would have to be avoided. And I think the same could be said for the Whalen.
Can I just follow up on that?
presentation.
The prejudice which flows to Lyle Menendez from having him testify in front of Eric Menendez's jury is if the court were to rule that certain areas should not be explored because those areas were not admitted against Eric Menendez. The effect of that ruling would be, as to Lyle Menendez, that all the most prejudicial aspects of the testimony that's so far been elicited as to him have to be segregated out and highlighted for our jury in a way that would never happen if we could just deal with our jury alone. So it gives the prosecution an unfair advantage of making it look artificially like these issues are either of more importance or somehow have to be segregated and highlighted in a separate proceeding.
Right? And as far as each defendant testifying before the other defendant's jury, I take it you object to that as well,
Yes.
as far as Eric Menendez testifying before Lyle Menendez's jury.
Yes.
All right, I'm talking now to the Lyle Menendez lawyers, since they were not here yesterday. I just wanted to ascertain that's their position as well. All right. So that the defendants both can hear what it is that the people propose to do in light of the objections of the defendants. What is it that the people intend or want to occur during the testimony of, at this point, Lyle Menendez, since he is the first who is going to be testifying?
Your Honor, my guess is that Whalen Menendez will testify about not only the events of August the 20th, but generally his whole life, since it appears that from the witnesses that we've had, that they are putting his whole life and his whole state of mind at issue. Therefore, it appears that not only will his credibility be at issue, not only will the events of August 20th be at issue, but his whole life will be at issue. Now, it's hard at this point to say precisely what the cross-examination is going to be. However, I think it's fair to say that
Now, let's back up. I'm not talking about the specifics of what is not going to be brought out. I'm just asking the mechanics of it, how you intend to have Lyle Menendez testify before both juries.
he would take the stand and testify on direct, and then we would cross-examine, and then I would cross-examine him.
And what is
In the
the
normal
theory of why he's permitted to testify before the Eric Menendez jury at a time when the defense is still putting on its case? If the Eric Menendez defendant is not calling Lyle Menendez as witness.
Under the same theory that any defendant testifies in a two-defendant case, he's a witness in the case, he's chosen to testify. The defense chose to have one trial. If the court will recall during the severance motion, one of the arguments in favor of having one trial versus two is that they could be witnesses for each other. Now it appears they've abandoned that. But that was one of the reasons that the defense made the selection of having one trial with two juries.
Well, the people wanted one trial with two juries as well.
That's true, but so did the defense, and they said after careful
To be
consideration.
more precise, as I recall it, there was a split between the prosecutors. Mr. Kuriyama wanted two separate trials, one after the other, and you preferred to have both together with.
Does the court
That
recall?
remains to be seen.
Skating for over 45 years has taken a toll on my body. I take Cunol turmeric because it helps with healthy joints and inflammation support. Why Cunol? It has superior absorption compared to regular turmeric. Cunol, the brand I trust.
That the defense also said that after much, and I believe it was Ms. Lansing who made the comment, that it was because they wanted them to be witnesses for each other. There's no reason why Lyle Menendez should not testify in front of Eric Menendez's jury. I mean, there's no reason he shouldn't. He's a witness in the case. This is a trial. This is not two trials. It is a single proceeding. It seems to me that any case where you have two defendants, they could make this argument. And therefore, you would always have to have two juries anytime you had two defendants where one wanted to testify.
Well, their position is different here. And bear in mind, the reason I'm asking these questions is that somehow the position of all the parties has to be put on the record and the reasons for it. And it's not for the court to do that. It's for the lawyers to do that. That's why I'm asking you to do it. The difference is that we do have two juries here, and that's the position of the defendants, that they have two juries. Therefore, they have an opportunity that wouldn't exist in a one jury situation to testify only before one jury rather than in a joint trial where one jury decides as to both defendants. So go ahead, you were
Well,
arguing your position.
yes, it's our position that he's a witness in this case, in this trial, and he should be testifying in front of both juries, especially since I believe from the opening statements it appears that they acted jointly on the night in question, and there's no reason why both juries shouldn't hear one of the two surviving witnesses talk about what happened that night.
And without getting into the specifics at this point, which I think we probably will get into a little later, are there certain matters that were brought out during the people's case in chief in relationship to Lyle Menendez that the people would not intend to bring out during the cross-examination of Lyle Menendez? And or are there things that have not yet been brought out that could be brought out that people don't intend to bring out during the Lyle Menendez cross-examination?
It's hard to say because I haven't heard it. I think that the areas of inquiry would deal with his statements to the police, and I should note that the statements to Sergeant Edmonds are in front of both juries. Even he testified to the August 21st statements in front of both juries.
Go ahead.
Okay, looking at this list here of separate witnesses before the Lyle Menendez jury.
Yeah, don't tell me specifically. I'm just asking you,
Yes.
Are there some things you would not intend to bring out?
Yes, there's certainly some things I do not intend to bring out.
And are there some things that have yet to be brought out in the Lyle Menendez case that you wouldn't intend to bring out during cross-examination unless something unusual occurred?
I would suppose that's correct, but I'm having trouble conceptualizing.
Well,
And for instance, there's some.
assuming there has been a list prepared here and it lists certain things that are of concern to the defense. So just using that as a basis of discussion, are there things on their list that have yet to be brought out? There was a list called issues
Yes.
regarding Lyle's cross-examination.
Yes,
Some of those things I've never heard of, some I have.
Yes, Your Honor, I would say that there are issues that have not been presented before either jury. That, for instance, on the last page, issues regarding Lyle's cross-examination, issue number 5, for instance. That's not in front of the juries right now.
Okay,
I
and
intend to
neither is
cross-examine.
number 4 and neither is number 7,
And at number 6 as well. In fact, nothing,
6, and also number 1.
nothing on this page except for 8. it appears.
Are there going to be any of those things that you would intend to bring out during his
Yes,
examination?
I intend to bring out
Well, all of them or just some of them?
1.
Well, don't even go through it right now. Just
Yes.
what I'm trying to do is determine whether there are some things you don't intend to go into, and you can discuss that with counsel and work out among yourselves those things that you wouldn't go into at all, so that we don't have to consume court time on them.
Your Honor, I hate to pin myself down though, because if I say I'm not going to ask about, like, say, number 8, and then they go into it, or this is somehow brought out, then I've been precluded from cross-examining. I don't want to get into a situation where I agree not to go into something, and then they go into it.
Well, obviously, if it's brought out by the defendant in direct examination, then that becomes fair game. The issue at this point is whether you would bring it out yourself if it hadn't been brought out on direct. That's all I'm asking, so that we can narrow the issues a little bit here, so we don't have to discuss each and every one of these things. And it requires some thought and consideration by counsel as to what you expect your examination to be. I don't intend to foreclose anything at this point, because I really don't know about lots of these things, but I want you to focus on it. And if you can, by doing that, confer with counsel on things that might not ever come out, then we can limit our discussion. Let me go ahead with some other matters here, just to look ahead for a moment. After Lyle Menendez testifies, what is the next evidence that's going to be offered by the defense?
It depends partly on how long it takes, how long his testimony takes in scheduling considerations. It was our plan before to put on one of his experts immediately after him. We also have a number of other witnesses we would like to call, whether that's then or after Eric testifies. We haven't determined, but it's my anticipation that Eric will testify fairly shortly thereafter, but that's more than 8 months since thereafter. It depends, it really depends on everything. It depends on whether Lyle Menendez testifies in front of both juries. Our feeling was that if Lyle was only going to testify in front of his jury, we didn't want our jury to go bye-bye for 2 weeks while all of the corroborating evidence of his went on. So at that point, if they were testifying only in front of their own jury, Lyle would testify with one of his experts, then Eric would testify with one of his experts, and then we start doing corroborating witnesses for each of them, sort of in a up and back way, so neither jury disappears for very long. Now, if it should turn out that they're testifying in front of each other's juries, then Lyle can put on his whole case, I suppose, or as much of it as he, because I have a problem with 2 of my experts who aren't available till the 27th. So under those circumstances, Lyle can put on as much of his case as he has witnesses available, since our jury would not be gone. But it's a matter more of scheduling problems than strategic problems.
Well, I will indicate it to you, as I did to the jurors, that I don't anticipate, unless something unusual occurs that's beyond our control, that we will have delays as we have had here. That it's unfair to the juries, and it's a very expensive proposition whenever we delay a trial such as this. If it can be avoided, it should be avoided, and it's the responsibility of counsel to have your witnesses, more witnesses available than we have time to accommodate them, so we don't get into a situation such as we had where we don't have enough evidence to fill out a day. Let me go ahead one step further here. You mentioned experts testify, and you referred to experts as experts for one defendant or the other defendant. Is that the way it is, that one expert is testifying in regards to one defendant and another as to the other defendant?
Yes, they weren't evaluated by the same people. They were evaluated by different people, by and large.
What does that mean, by and large?
It means there's one expert, I think, who may have a small contribution in Lyle's case and a much larger one in Eric's. That's Dr. Vickery. He saw both of them early on, but he actually met me and Dr. Ann Burgess. And Ann Burgess may testify briefly in front of Lyle's jury on a crime scene issue, but she didn't do any evaluation of Lyle. She didn't spend any significant time with him. She's an evaluator of Eric.
And
She also has a background in crime scene investigation and reconstruction with the FBI, so she would have been asked to testify to that issue before both juries.
But she actually spoke to both defendants?
She only spoke briefly to Lyle, but she's did her evaluation of Eric over 50, 60 hours.
But she spoke to both defendants?
Spoke to Lyle Menendez with regard to doing her evaluation of Eric. Yes.
Okay. And Dr. Vickery spoke to both defendants?
Spoke to Lyle Menendez as part of doing his evaluation of Eric. Right.
All right. And is it anticipated that in the testimony of these experts that they would refer to the conduct or statements attributed to the other defendant in any way?
No.
That Dr. Burgess or Dr. Vickery would not testify to what the other defendant told them?
I think I will probably not be calling Dr. Vickery. He's on there as a potential witness. I do not expect I'll be calling him. With regard to Dr. Burgess, Ann Burgess would just be talking in a general sense about crime scene evidence, not with regard to.
And you have some other experts who have interviewed each defendant extensively.
Yes.
One of them being Burgess, who interviewed Eric Menendez extensively and only briefly with Lyle Menendez,
Right.
but would be testifying regarding the incident in some fashion. I don't know what the specifics of her testimony would be, but
Just the crime scene analysis.
as to Lyle Menendez.
Yes.
And as to Eric Menendez, she would be testifying to
her evaluation of him and to her review of documents or interviews with witnesses, her opinions and conclusions about Eric.
and she spoke to Lyle Menendez about the crime scene.
No, spoke to Lyle Menendez just in background material with regard to evaluating, just as you would talk to any other family member.
So, and when we say the experts reviewed witness statements, did those include review of statements attributed to the defendants by witnesses?
Statements? No.
Reviewed it to the defendants by witnesses? You mean like Craig Signorelli?
Ozio, anybody?
I think they did review some of it, yes.
Well, you told the juries, my recollection, that they reviewed just about everything, these
They did.
experts.
I mean, my experts have reviewed just about everything, including much of the testimony. We've just sent them the testimony of the defense witnesses so they would understand what is specifically before the jury. But I don't know what we haven't delineated, they haven't told me what they're relying on in the formation of their opinion, so I don't anticipate they're going to be talking about every single thing they saw.
Well, if they reviewed things, and including statements of the defendants, wouldn't it be likely that they would be relying upon the statements of the defendants in forming their opinions?
I don't think things like Lyle's statements to Glenn Stevens helped form their opinions, and in fact, I'm not sure that my experts ever saw that. I doubt that they did.
Well, what I'm getting at, as you could obviously determine, is that isn't it likely that in the examination of these experts that either the direct or cross-examination would involve reference to what the other defendant has said or done in some fashion, since, as I understand it, this is a joint defense and the incident occurred in some fashion, both defendants acting at the same time, doing things jointly. Although the specifics haven't been brought out, it seems to be the tenor of what the defense has put forward.
We have totally separate experts who have reviewed different materials. What Ms. Abramson sent her experts and what I'm asking from my experts may be different and are different, I'm sure.
So,
I don't think, other than the fact that they interviewed the other brother in terms of just as they would interview an aunt or a sister or anybody they were evaluating, for that kind of background material, they didn't spend time.
Well, let me go one step further here and ask this question. It's hard to visualize exactly what will transpire, but because I don't know how these experts are going to testify, it hasn't been presented to me, and we certainly have to wait for that. But isn't it a likely scenario that during the testimony of the experts, say, regarding Lyle Menendez or Eric Menendez, whichever testifies first, that examination of that expert, either direct or cross, could encompass what the other defendant has said about the incident itself, what has been testified to in this trial by the other defendant, in an effort to cross-examine perhaps the expert, to test the expert's credibility and the validity of the opinions by putting forth before that expert what other information the expert could have considered in making a decision or forming an opinion about the matter. And if that is so, then wouldn't it be appropriate for the trier of fact, not just the expert, but the trier of fact, the jury, for each defendant to be made aware of what the other defendant has said?
Could I respond to that?
Yeah.
I think there is a difference between the experts saying they're aware of something on the one hand, and on the other saying that they did not use that material as the basis for forming their opinion. And I think our experts would say they're aware, for instance, of trial testimony, they're aware of pretrial statements of the defendant, such as Skip Lowe and other witnesses, but that their opinion is based not on those statements, but based on other matter which is properly considered. And I would refer the court to a Supreme Court case, People versus Caro, which is 46 Cal 3rd.
Yeah, I'm familiar with the case and as to what experts consider versus what they could have considered.
This is on another issue, which is the issue, one of the issues raised in the Caro case, I know we cited it for a number of propositions, was can the prosecution cross-examine on material that the expert says he was aware of, but didn't use it in front of his opinion?
That's what I'm referring to.
And the court says if the doctor had testified and had asserted that his opinion was based in no part on statements by defendant about the events surrounding the crimes, the prosecution might have been foreclosed from cross-examining him about such statements. So, and they cited the case People versus Reyes, which so it would be our position that according to this case, that the prosecution would not be entitled to parade hearsay statements that had been admitted up to that point only in front of the other jury, in front of the second defendant's jury under the guise of testing the expert's opinion. If the expert in good faith says, I form my opinions by not relying on that jury.
And let me just clarify one thing that for the court, in case the court is operating under some other assumption. My experts, mine, the ones that evaluated Eric, did not interview Lyle Menendez concerning the facts and circumstances of the shootings. That wasn't their purpose in talking to him. Their purpose in talking to him had to do with the child abuse issues in the case, the treatment of the parents towards Eric as he, as a witness, perceived them. And it was just a way of corroborating, I suppose, on some level at an early stage of their investigation. Now, I don't believe either or any of my three evaluating experts rely on what Lyle said to them. We've developed a lot more evidence since those days through the witnesses that have testified. So it isn't a situation where they're going to be evaluating the last stage of this long abusive history, the stage where the shootings occur, by relying upon Lyle's version of those shootings or the events that immediately preceded them. That information came to them from Eric. So I don't see a necessity in order to provide fairness to all sides. I don't see a necessity for our experts to testify in front of each other's juries, nor do I see a necessity to put on the other defendant because of anything the experts are going to be saying or relying upon.
No, I was never proposing that experts relating to one defendant would testify before the other defendant's jury.
But if that's true, then it really is if the court were to rule that each defendant must testify in front of the other jury, then you're depriving the defense of valuable evidence if the experts don't, because the experts who evaluated them, in a sense, corroborate their life experience by indicating that they fit certain profiles or patterns or demonstrated certain symptoms or behaviors that are typical of abused kids. So if the defendants testify in front of each other's juries to any extent, in any extensive way, then the experts actually have to, in order for the jury to understand the credibility and explain each defendant.
Well, we're jumping ahead. I didn't contemplate that as part. It's rather complicated now. That's not part of this discussion, and I don't see any need to address it at this point. Is there any anticipated conflict between the two defendants in their testimony?
No, it's not an issue of conflict between their testimony. It's an issue of conflict with the baggage on the one hand, and conflict with the comprehension of our juries. For a defendant to be cross-examined about matters that our jury, for example, knows nothing about, is confusing to them. It misconstrues issues. It doesn't give them a proper basis for assessing the credibility of that defendant who's talking. It will necessitate recalling witnesses that testified only in front of one jury to now testify in front of the other, so the credibility of those people. I mean, it will destroy all the separation and duplicate all the separated testimony that we've had thus far.
Well, that only occurs if that evidence is brought out before both juries.
Exactly.
It could be that the prosecution, through whatever decisions they make and rulings the court makes, would prevent that from occurring. I don't know yet, because I don't know exactly how the prosecution envisions its cross-examination on those subjects that were introduced only as to one jury. The reason I asked about conflict between the two defendants is the document filed by the defense for hearing on June the 7th. It was filed June the 7th regarding notice of motion and motion for separate juries. And in the document, page 14, there's reference, and I'll quote it. There is also another important dimension to this case. Eric's response, underlined, defines as crucial to his defense the theory that Eric was fearful of Lyle at the time of the alleged crimes. Certainly, Eric is entitled to show the reasons why he harbored his fear, including evidence that Lyle threatened him or committed other acts of misconduct. just as certainly Lyle would be entitled to show that Eric needed no prompting to engage in criminal conduct, which again may involve evidence of Eric's prior criminal activity. And then it goes on to cite a case and concludes by saying, of course, the direct beneficiary of all this co-defendant infighting will be the prosecution, who can simply sit back and watch the brothers destroy each other, end quote. From what you've said to me here, that is not contemplated in the examination of either defendant. There is no conflict between them. There is no dispute between them on any subject. Is that a fair statement?
Well, I can't answer that in the presence of the prosecution because of other matters. I can answer that best in camera.
In regards to what? An offer of proof as to what your client would testify about?
No, not so much that, but it would relate to penalty phase issues if we ever get there.
Well,
And that would relate to.
This response then that I read only related to penalty phase issues and not guilt phase. Obviously, if a defendant's version of the events was he was compelled to do something by the co-defendant testifies before the jury in the guilt phase, the assumption is that his testimony would be the same in the penalty phase.
No, that was aimed at penalty phase because, as the court knows, the rest is not defense to homicide. But it is a mitigating circumstance in the penalty phase. And as far as why that, I think that was addressing at the time statements made by Mr. Signorelli. But as I say, I could make a further offer of proof, but only in camera, concerning that particular issue. And as far as the guilt phase at this point, that's not an issue that we would expect to come up. But I can't be certain. And I can't describe it further except in camera.
Well, I'm
privileged issues.
okay. I'm not inclined to, at this point, have an offer of proof that would foreclose the prosecution from being in a position to respond. I don't think it's appropriate. All I do is read the documents you file, and I noticed that, and I noticed your statement here that there is no conflict between the two defendants in their testimony. So that is not an issue that the court has to consider in making a decision as to whether the testimony should be before one jury or both juries.
Well, the only matter of concern, I mean, there is no conflict with respect to them blaming each other or claiming that things happened differently than they did happen. But there is a concern about a jury doing in the guilt phase what there's been much concern about juries doing in the penalty phase, which is comparing and contrasting the defendants and their level of victimization. And when each of these defendants testifies about their life history and their victimization, and when their expert testified about it, I think there's going to be a relatively graphic picture painted of what was done to them. And I think that what we want to avoid is juries, even though there are separate juries comparing and contrasting the experience of one with the other and deciding, quote, their defendant, the one they're reviewing, didn't have it as bad as the other one. And since we're not relying on the other defendant's statement for their testimony for any purpose in formulating our defense theories and arguments and facts, I don't think that we should be subjected to that potential harm.
Well, I don't contemplate that as a problem or an issue, and that certainly was not the basis of any decision regarding one or two juries.
Well, I understand that.
That was the position put forth by the defense, but we've had many a jury trial where there's been one jury and multiple defendants, and that certainly the argument you're putting forth wouldn't be a compelling reason to have separate trials, or as the prosecution says, every trial would be with separate juries. The situation here is a little different than some other cases where there are dual juries. Normally in the past, not always, but normally in such situations, there is an issue of a statement attributed to one defendant or another. And then potentially during the course of the trial, there is some additional evidence that's introduced as to one defendant or the other, but not as to both, and not before both juries. But at the end, what often happens is that there is no testimony offered by either defendant or by the defendant who was a subject of the evidence that has been offered only as to one defendant, not the other, or the defendant who made the statement that was received only by one jury. Often that defendant doesn't testify. So here the situation is different, that we do have that testimony. And obviously the situation could very well have been different if there was one jury as to, in this case, as to whether the defendants would have elected to proceed this way as to both testifying or as to one testifying. But what I am going to do is invite counsel to try to narrow the issues here, just take a break and try to discuss the matter as far as those matters that if Lyle Menendez testifies before both juries, that counsel would discuss those matters that the prosecution does not feel that it would bring out or want to bring out during the cross-examination, so that when I resume this hearing, we will have narrowed the issue somewhat, hopefully anyway, and then be able to arrive at a decision as to whether or not there be testimony before both juries. Yes.
With regard to item number 6, we need to have a hearing in camera and ex parte. There are some very substantial issues with regard to that item, which I think the court should be made aware of.
Well, before I do that, let me find out whether the prosecution intends to go ahead with that.
Yes.
You do?
Yes.
All right. You'd have to give me some more information as to why we should do something ex parte.
May I do it at the sidebar, Your Honor?
Well, just generally right
It
now.
involves the attorney-client privilege. And I can give you the documents they're relying on to show you why.
All right. Was this a statement? This is a statement that was included in the people's original offer of evidence. You have some additional documents you want me to look at in regards to that?
I'm not sure. Did you provide the transcript?
I believe it's in here. I'll look again, but I'm pretty sure it's in here.
I have a copy. If the court doesn't have a candidate, I have a copy.
Statement number 25.
Thank you. Yes, Your Honor, statement 25 in that motion. I have it with me. I don't
Okay.
know-
Well, I have your document, but if there's something else that the defense wants me to look at.
It's, no, it's contained therein, and I think if you start at page 56, the relevant portion is just a few pages long, but I think the problem becomes apparent
Okay.
if we do that.
All right. And otherwise, I'd ask counsel to take some time to discuss the matter as far as the mechanics of it and what it is that that the prosecution intends to go into on cross-examination. And then when you're finished with those discussions, we'll continue. How long do you think it'll take to do that?
Half an hour.
We can discuss it.
All right, then we'll take a recess. Is that about right, or do you think?
Yeah, I just have a question.
Yeah.
So today we're only dealing with what I'm going to cross-examine Lyle Menendez about and not what Eric Menendez will be cross-examined about. Is that correct?
Well, at this point,
This
we're just
negotiation.
dealing one defendant at a time. I don't see that they're locked together as far as these discussions are
The only
concerned.
difficulty with that is before I put Lyle Menendez on the stand, I need to know if Eric Menendez is going to be testifying in front of his jury and all the areas that Eric Menendez, the jury has already heard about, are going to be coming before my jury. And my jury, who's never heard of Craig Signorelli or Casey Whalen or Doug Doss or
Well, some of these
any of the other,
are,
I mean, we have,
many of these witnesses for both defendants are witnesses that have no real significance other than some history of
I think,
relationships.
I think with regard to
Some do and some don't.
some of them.
You
have-
mentioned Signorelli and Whalen,
And,
they do.
well,
but,
Whalen is impeaching of
Yeah,
Signorelli.
but a lot of them don't. So,
Ozio.
well, there's going to obviously be a distinction here between certain statements made that are the subject of cross-examination. And there's been some briefing on the subject of right of confrontation and issues of that sort. The defense has presented to the court some briefs on that subject. The prosecution has filed something within the last day or so and did so earlier. And that issue, I believe, is one that can be easily resolved and won't constitute a barrier to the examination. So it's primarily one of Evidence Code Section 352 more than anything else, and or the defense position that it's somehow hearsay. Otherwise than a Randa Bruton type problem, which I think is pretty much resolved. I'm prepared to rule that it is in California.
Can I have one general
Yes.
argument to the court? The court asked the prosecution what authority there was for the prosecution forcing one defendant to testify in front of the other person's jury, and that question remains unanswered. I don't think they cited any authority to the court which would allow it. And I was going to ask the court to consider during the break an evidence code section, which is evidence code section 772B, which says that if the witness, it's a section dealing with phases of examination. And it says, if the witness is a defendant in a criminal action, the witness may not, without his consent, be examined under direct examination by another party. And it would be our argument to the court that that section is violated when the prosecution, in effect, is deriving the benefit of the direct examination, for instance, of Eric Menendez, forcing the Lyle Menendez jury to sit in on that direct examination.
Well, it's cross-examination.
Well,
you're talking about the direct examination
I'm talking
by
about focusing
his lawyers.
just on the direct examination, for instance, of Eric Menendez. If the Lyle Menendez jury, during their presentation of the case, stands up and says, we don't wish to call this witness, then what authority is there for allowing the prosecution to force our jury to listen to the direct examination of Eric Menendez?
Well, because Eric Menendez is not the defendant as far as Lyle Menendez is concerned. Lyle Menendez is the defendant.
That's true.
That section doesn't apply. It relates, the obvious import of that section is that the prosecution can't call the defendant to the stand to testify against himself. Isn't that really what it says? It's just a reiteration of the United States Constitution.
I'm not sure it seems to be written broader than that. If the witness is the defendant in a criminal action.
Okay, or another defendant in the same action. If there are two defendants sitting there at counsel table, the prosecution can't call one to testify against the other until and unless that other is called by his lawyer, which is what is happening here. The lawyer for Eric Menendez would be calling Eric Menendez to the witness stand. So in that regard, the people's position is this is a joint trial and that Eric Menendez's lawyer is calling him as a witness. So that isn't what that section relates to.
That's our argument to the court.
Okay,
that the language is broad enough and that the people, if they had any right at all to force this procedure, that the appropriate way to do it would be in rebuttal, not to put us into a position of, in effect, being forced to listen to a direct examination during our case. And it would be no different if we decided during the prosecution's case that we would like a witness to appear in our case in chief. It's a matter of the order in which the witnesses are called and the orderly presentation of the evidence.
Well, except if that witness would become unavailable at a later time because he's already testified, then the lawyer for that defendant would object to that witness being called back because he's a defendant in a criminal case and the prosecution can't call him back. So the people only have that opportunity during the presentation of the other defendant's case to put that defendant's testimony before the other defendant's jury.
If that's a correct view of the law, I think the prosecution's position that they originally put forward in their pleadings to the court was that they had the authority to recall a defendant who had already testified in the same proceeding, that was a waiver. And the cases that they cite do in fact say that. So if that's a correct position, then there's nothing to preclude the people from calling one or the other defendant as a rebuttal witness. There's no valid claim of privilege according to that argument.
I bet you would take a different position later on if that ever happened.
Well, all I'm suggesting to the court is that that is an issue that needs to get resolved along with this other discussion, because if in fact that is a valid position, then it seems to me that the people's correct remedy is to seek to call one or the other defendant in rebuttal at a point in time in the case when the court is then in the position to decide whether it is or is not proper rebuttal testimony.
All right, well, that's an interesting position as well. All right, but regardless of the merits of that, I'm going to ask the council confer about the testimony, and just to expand on it, to give Eric, allow Menendez counsel an opportunity to evaluate the overall presentation. Council should also confer regarding what evidence one would anticipate being the subject of cross-examination of Eric Menendez as well. Doesn't have to be definitive, as I say, and contrary to what the positions have been expressed here, as council are aware, positions change, and it could very well be that after testimony of Lyle Menendez, if there is such before both juries, the defense for Eric Menendez might not call Eric Menendez. That's always a possibility as well. You never know until you get there. So I'll take a break and let council discuss the matter, and we'll tentatively resume at 3:15. If you need more time, just let me know.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
In the trial, the attorneys are all present, as well as both defendants. In regards to what, if anything, you have accomplished during the recess, have you been able to narrow the issues at all?
Your Honor, we went through them with regard to the separate witnesses before Eric Menendez jury. Prosecution has indicated that they would go into 1, 3, 4, 7, and 8. And the defense has indicated that they would go into all of the areas. In addition, the prosecution has told me that they would also want to go into an 11, 29, 89 conversation with Craig Signorelli. The BBC movie.
Hold on, don't go quite so fast. Okay.
And the screenplay.
All right.
With regard to the Lyle Menendez list, one or both sides will go into every witness with the exception of number 8.
All right, with regards to both sides, at this point, let me hear as to the prosecution on the Lyle Menendez list.
1.
And as far as which list we're referring to, the list of witnesses that already testified? Okay.
The prosecution would go into 1, 2, 4, 5, 6, possibly 9, and 10.
Your Honor, the defense has indicated, as to this list of the 10 witnesses, that they would go into many of these witnesses on direct. Okay, and then as far as cross, the only one that I could say that I wouldn't cross-examine about is number 8.
That you would not.
Right, and maybe 7 and 9, depending on what the defendant says. I just, it's hard to plan a cross in a vacuum.
So as of now, let me recount the ones that the prosecution would go into in cross-examination of Whalen as far as witnesses are concerned. These are witnesses who have already testified. Are Goudreau, Stevens, Zoller, Edmonds, Whitkin, Elmore, and Oziel.
And Wiskowski, number 3.
And number 3.
Yeah, I believe she said possibly 7 and 8, which I think covers the rest.
I can't imagine asking questions on number 8. But we weren't able to agree very much. I think that's fine.
Okay. All right.
And you don't want information with regard to the issues page.
Yes.
They've indicated that they will go into the 8 that are listed on your sheet, plus 9 and 10 would be added.
And those are what?
9 is the tennis contract through Mark Heffernan. And 10 is the BBC.
All right, these are issues that relate to Eric Menendez.
Now, these are issues that relate to Lyle Menendez, which they would anticipate going into, so they would be before the Eric Menendez jury.
These would be questions asked of Lyle Menendez.
Correct. Cross and prosecution. We have issues with regard to virtually all of these, which we need to be able to report on.
All right.
For our own purposes, regardless of how many juries are testifying in front of the Eric Menendez's jury has
Okay.
their own issues.
All right, just in a broad brush statement, anyone else have anything to say without getting into detail?
Mr. Kuriyama indicates that his intention vis-a-vis examining Eric Menendez would be to use everything reflected on the rebuttal witness list, which includes witnesses Darian Braun and Larry Pollock, which has to do with Eric Menendez being ripped off by these concert promoters. Heinberg, who the court had an opportunity to read the statement of this morning. Mr. Kuriyama also indicates he intends to go into the details of the so-called Calabasas burglaries, apart from what's contained in the stipulation. And of course intends that all of this be in front of both juries. I'm not sure what else. I'm not sure if Mr. Kuriyama is intending to try to elicit anything about the jail escape plans or the letter through Eric Menendez, who they've never offered that against, if it were not brought out through Lyle Menendez in front of Eric's jury. I'm not clear on that. And I assume they intend to elicit through Larry Cohen that Eric may have looked at property and may have made an offer on property, even though there's no paperwork to reflect that. Larry Cohen is a real estate broker, talking about a time in February of 1990. And we would be objecting on any basis to Mr. Cohen's testimony to Craig.
As I indicated, I didn't want to get into
Okay, I
details,
just
so you're
want you
giving
to-
me a lot more than I really need to know at this point.
Okay, well, apparently they just feel that once the defendants testify, they have a right to bring out anything they know about them in any form in front of, not only in front of their own jury, but in front of the other defendants' jury. That's their basic posture.
All right, let's then focus on the first defendant who will be testifying. That's Lyle Menendez, and issues that relate to his testimony. And let me ask the prosecution, you mentioned all these things, or they have been mentioned, as to what you intend to go into relating to Lyle Menendez. Is there any position that the prosecution has as to whether those matters should be confined to hearing before the Lyle Menendez jury, or that it's your position that they should be heard before both juries?
It's
it's our position that insofar as they would attack his credibility, which is probably the main reason to bring up many of these things, that they should be in front of both juries.
And that is to each and every one of these, or there are some that don't fall within that category?
No, I think basically they, at least this list, the last page the court has, the issues regarding Lyle's cross-examination. I think they all tend to.
All right, if you could turn on your mics, it's kind of hard to.
I'm sorry, Your Honor.
Your mics are on.
Yes, I indicated counsel number 7 is something I'm not sure I'd go into, but number 8 and 9, for instance, are already in front of Eric Menendez's jury. In fact, they're only in front of Eric Menendez's jury right now. 1, 2, and 3 may become germane depending on what he says. But those items would be used.
When you say depending on what he says, you mean on direct examination?
Yes, on direct examination.
All right, you're talking about the Calabasas burglaries and something referred to as a Princeton burglary on April 24th, 1988?
Correct. And I believe I made a copy for Mr. Burt to give the court of the particulars of that incident.
And these were matters that would only be touched upon by the people in cross-examination if they are somehow raised by the defendant in his direct examination?
Yes.
All right.
No, wait. It depends on what if he doesn't talk about the burglaries, I'm not saying I'm not going to bring them up. It may be germane to another issue, like his mental state. In other words, if he doesn't talk about them, but I think, and the court agrees on a sidebar conference that these are germane to his state of mind, then I would bring them up.
All right. At this point, you have no way of knowing that you would. You don't go into the cross-examination with an idea that you would be bringing it up. Is that what you're saying?
It's certainly in the arsenal. I don't know if I'm going to use it.
Okay.
Can I add one thing to that?
Yes.
When the prosecution says it's certainly within the arsenal, it would not be our intention to testify about any of these first 3 burglaries. And in fact, we would claim our privilege against self-incrimination as to any testimony concerning any of these 3 events. And it was my understanding from talking to the prosecution that they would be offering these 3 incidents under a 1101 theory, number 1, and number 2 under a Wheeler theory on the issue of credibility. So it seems that once Lyle Menendez testifies, his credibility is an issue. And I think, given the fact that his credibility is an issue, that if the prosecution is true to what they said during our discussion, that they would then seek to use these incidents, if not on an 1101 theory, at least under a Wheeler theory. So we would be raising a motion in limine at this point to preclude them from doing so under a Wheeler theory, and also under an 1101 theory, since there's no foundational showing as to how 1101 would apply, absent some indication there's some similarity in that it proves some issue other than character.
Well, was that your intent?
Your Honor, it's very hard to discuss this until I know what he's going to say. But if the defendant's going to say that these crimes were committed purely in self-defense, that there was no financial motive, that he is an honest person, then certainly I would bring these up to impeach. And there are other reasons to bring them up as well. If their experts testify about his mental state, I'm going to ask about, did you consider the fact that he committed burglaries? That in evaluating whether he's a sociopath or a victim. So I think that these are going to be germane to the issue of his mental state. But I can't say precisely how until I know what he's going to say. Now, there are some defenses that could be offered in a criminal trial, which would not give rise to me asking about these things. But
as you are aware of the defense that will be offered in general anyway, is it a fair assumption that this will come out?
Yes, I think that's a fair assumption.
All right. And as far as Lyle Menendez is concerned, his objections have to go to their admissibility at all So let's focus here because we're getting off in all different directions here. Let's focus first on the evidence that is going to be addressed by Lyle Menendez in his direct examination so that we can then focus on the objections by the Eric Menendez counsel.
Well, Your Honor, I can indicate that one of the things that we need to consider with regard to the direct is which, if any, or all of these issues will be coming in, because if they are ruled admissible, then we
Okay,
may
let's
want to
focus
deal with them
on,
on direct.
I understand it. Let's focus on excluding Eric Menendez from the case, just assuming that you had Lyle Menendez as a witness, those areas that you would go into that, or that Eric Menendez is concerned that will be brought out during the direct examination. You've conferred, so there's must be some knowledge by Eric Menendez on those subjects. So let's deal with it that way. Because that's the first issue here to decide on as to the direct examination of those matters that would come out during the examination of Lyle Menendez and would be objected to by Eric Menendez.
Well, I think as a starting point, we have the 10 witnesses who were called in front of Lyle Menendez's jury only. And we would certainly want to address issues raised by those witnesses.
All right.
Spending, bodyguards, the computer.
Statements to Glenn.
Statements to Glenn, statements to Glenn Stevens, statements to Oziel, which are not in front of Eric Menendez's jury. We would certainly be going into those areas.
And this would be what, in some way contradicting the testimony of these other witnesses, denying that these statements were made?
Explaining, in some cases contradicting, in some cases expanding on it, in some cases explaining.
All right, and as far as Oziel is concerned, his testimony was rather brief in regards to Lyle Menendez. It was rather focused, and his credibility has been extensively examined before both juries. So
I think the content, I think there's discussion particularly about threats. There's some other areas that we've gone into only in front of Lyle Menendez's jury. And we
yes, I
certainly
understand
intend to
that, but
address
it would be, I assume, areas that, well, either denials by Lyle Menendez or explanations or something along those lines. Is that right?
Correct.
Okay. And what is the defense objection to that? The Oziel testimony, starting at the bottom of the page.
Bottom, oh,
Number
you mean
10.
number 10. What's our objection
Yeah.
to it, Your Honor? Our jury has not heard anything about threats. They don't have any context in which to accept Lyle Menendez's explanation or denial, assuming that's what they're going to hear. Nor is there any information that, I mean, Eric wasn't there, so he doesn't know what was said. And I just think it shouldn't come in front of Eric's jury. As far as things said when Eric was present, that doesn't give us as much trouble as things that Lyle's going to say were said or not said when Eric isn't there at all.
Well, whether he was present or not, if it's subject to cross-examination and asking whether you made such a statement, and
He's going to say, let's assume he says no.
then that's typical cross-examination of a witness. And the jury, your jury will hear whatever the question is and the answer given.
Yeah, but the problem is once he does that, you see, since we're not calling this witness and we don't want to have to deal with his credibility, let's just
This
take
witness being,
Lyle Menendez.
all right,
Let's just start with that. Let's say now that he has denied making the threats that Dr. Oziel says he made. Now the people will claim, aha, now Lyle's credibility is an issue. And then all this other stuff they will claim is now relevant. See, we're concerned about their bootstrapping something he says on an issue like Oziel into a justification to attack his credibility across a vast spectrum, including other acts that Eric had nothing to do with. Just to sort of
air all the, no pun intended, dirty laundry possible, and to air it in front of his brother's jury so that it will have that nice, shiny spillover effect that I'm sure the prosecution would like to obtain here. So we don't want to be in a position where Lyle Menendez's credibility is an issue, period. We're not calling him, we're not relying on his credibility, and we don't want to take advantage of it, and we certainly don't want to pay the price for its attack.
Well, but that would be the statement of any lawyer representing any defendant in a trial where a co-defendant testifies.
Except, Your Honor, in the ordinary trial where a co-defendant testifies, the evidence has come in front of the jury. Our concern.
Well, as I'm saying,
I mean,
your jury
the
would,
prosecution evidence has come.
your jury will hear the questions asked, the answers given, and they will not have heard the extrinsic evidence offered by the prosecution in the prosecution's case in chief.
Mhm.
They will not have heard perhaps extrinsic evidence that has already been offered by Lyle Menendez, if any, and I don't believe there really has been, on any of these matters. So all your jury would hear would be the questions and the answers. And it'd be up to you if you wanted to add to it by bringing in extrinsic evidence after his testimony to contradict any of the evidence that's been offered. You can evaluate the evidence that's been introduced in regards to Lyle Menendez and make a decision as to whether you want to bring in anything different. Your jury will have heard different evidence than the Lyle Menendez jury. That's true. But your jury will have heard it through the examination of Lyle Menendez. And then it would be up to you to make a decision as to whether or not anything brought out during that examination should be the subject of extrinsic evidence brought in.
That's not my concern with the respect to the Oziel issue, okay? But let me give you another issue where it would be. Lyle Menendez will get up there and testify, let's assume, hypothetically, that Glenn Stevens was lying about the statements. Now, my jury hasn't seen Glenn Stevens. It's of no comfort, I mean, and yet the people will ask a whole series of questions about Lyle Menendez, let's say on cross, concerning Glenn Stevens in an effort to impeach him. They will try to impeach him with this extrinsic evidence. Now, I'm in a definite disadvantage to show that Lyle is the more believable witness with respect to these issues than Glenn Stevens, because my jury did not see Glenn Stevens destruct on cross-examination, which he most definitely did. They didn't get to see that. And it's of no comfort to me that I can now bring Glenn Stevens in and try and take him through the same cross-examination where he admitted being a liar and an exaggerator and a phonier up of resumes, and that he misstated to the police that he granted all those interviews. I mean, as the court has noticed, giving someone warning before you cross-examine them does not lead to the most honest cross-examination. So it's of no comfort to me that, yes, I could now go haul in Glenn Stevens, the straw man, in the hopes that I can then knock him down as successfully as Ms. Lansing did, in order to show that Lyle is a truthful person because he's a co-defendant, he's a brother of my client, and if my jury thinks he's a liar, that can slop over onto my client.
Well, the jury would never hear other than a question, did you tell Glenn Stevens such and such? And your client saying no. That there's no evidence that your client ever told
Not
Glenn,
my client.
or that Lyle Menendez ever told Glenn Stevens anything other than the question being asked in a denial.
It can be asked 6 different ways. I mean, they can then hand him the police report. They can then.
No, who's going to hand a police report to the defendant and ask him whether?
Well, what is my jury going to make of this under 352? Isn't this precisely the kind of confusion of issues that should be avoided? Why should my jury be hearing about things they have no way of evaluating?
Well, they can evaluate it based upon the questions asked and the answers given, and you are the beneficiary of the defendant's denials.
I'm the beneficiary of having
Lyle Menendez denies making a statement to Glenn Stevens, and
But
there's
what
no
is
evidence offered that he made the statement. So how do you suffer a detriment from that?
Because let's be realistic. Although we know that a question, did you tell Glenn Stevens if they find that tape to Oziel, I'm, quote, is not evidence, that doesn't mean my jury doesn't hear it. That doesn't mean it doesn't register. And that doesn't mean they don't believe it. I mean, the problem is the reality of what juries hear. I mean, if they hear this whole line of examination of Lyle Menendez, even though the questions aren't evidence, it nevertheless will raise doubts in their mind about his credibility on issues that we haven't had an opportunity to adequately.
Well, look at it from the perspective of a joint trial, and assuming the people had not called Glenn Stevens and Lyle Menendez testified, and the people asked, did you tell Glenn Stevens this? And Lyle Menendez says no. And you're sitting there as co-counsel, and that's the end of it. What is that? How's that different? The jury hasn't seen Glenn Stevens, hasn't heard anything but the denial.
It is different. I'll tell you why it is different, because it's going to be brought out through the direct, not through the cross. Because the people have put on Glenn Stevens, they have forced Lyle Menendez now to make a statement about Glenn Stevens to defend himself, okay? And so it's going to come out through his direct, and then the people will, so my jury will hear it both on direct and on cross. That's a very different situation than if we had the kind of evidence where the people could simply ask one of the defendants, did you tell, had an inconsistent statement with something that they were saying, for example, in their direct testimony. If a defendant testified, I was driving a red car, and the people got up and without having called Joe Blow said, didn't you tell Joe Blow you were driving a blue car? I could see that happening. But here what's happening is because this evidence was presented in front of Lyle Menendez's jury, he now has to get up there and respond to it. So my jury has to hear his response, his explanation. And remember, Glenn Stevens also testified to his spending. Why does my jury have to hear his explanation for why he spent all this money? I don't care what his answer is. He isn't going to deny spending the money. He's going to admit it. And that sloshes over onto my client, who has his own spending evidence, and let the jury evaluate his spending. But why now, because they choose to testify, does the whole separation under 352 that we previously accomplished fall apart when I'm not calling him? I don't need his testimony, and I don't need the baggage that goes with it. If I were putting up his credibility, then I have to take the hit, but I'm not. I'm standing here saying I don't want him to testify, and we're going to be subject to the impeachments with negative information in front of our jury that, because of the relationship between these defendants, is bound to reflect badly on my.
On this general subject, since it obviously has mutuality here.
Absolutely, Your Honor. I mean, we're in exactly the same position. A number of witnesses were called in front of the Eric Menendez jury. Craig Signorelli testified. We weren't here. He's then impeached with the members of the Whalen family. We weren't here. Our jury wasn't here. And from what the prosecution has told me, they intend in front of the Eric Menendez jury to go into that. Well, what I'm saying is in front of the Eric Menendez jury, they intend to go into that, and I'm sure they have every right to. And Ms. Abramson, I'm sure, will want to have Eric Menendez talk about Craig Signorelli and Casey Whalen. Our jury doesn't have a clue what all that's about. They don't know who to believe. There's going to be this credibility contest described, and they won't have any idea what it's about. And Craig Signorelli is making statements that have to do with the crime, and our jury hasn't seen him. And so the position we're in then is, if Eric Menendez testifies and is cross-examined about those issues, what can I do? Recall Craig Signorelli, recall Casey Whalen and family members, so that my jury can get an idea of where this all stands. It seems to me that there was a decision made early on that certain evidence was relevant and applicably introducible against particular defendants. And I think if we'd made the decision that we wanted to call both of them in front of both juries, then we'd be stuck with the consequences. Obviously, we've made the other decision, that all of this other complication makes it too difficult. It's too complicated. They've got 18 witnesses they called who our jury's never heard of. And all of a sudden there's going to be testimony about Valerie Hart or Doug Doss or Barbara Zussman or Craig Signorelli, and our jury's not going to have any idea what it's all about. And I think it invites speculation, or it invites relitigating everything that we've done separately and undoing everything that we've done. And I think, although, I don't know that I'm really happy about this as an alternative. I personally, and I think that Ms. Abramson may have a different perspective on this, but if in fact there is inconsistent testimony and they are proper rebuttal witnesses, then maybe that's the way to go, rather than opening up all of these areas, either limiting the prosecution in what they can bring out in front of the defendant themselves' own jury, or making us hopscotch around to avoid all these various areas, or bringing in evidence that's going to only confuse our juries. I mean, none of those alternatives seem to really be without substantial problems. And so I think it's my perspective, and as I say, Ms. Abramson may have a different view, is if they testify and they are inconsistent and then they are proper rebuttal witnesses, then maybe that is the way to resolve the issue. I realize that the prosecution thinks here are two people who are going to have seen the same thing and who may testify inconsistently, and they want to be able to take advantage of that. And maybe instead of going this direction, where we figure out all these other things that are problem areas, they focus on the things that are appropriately admissible.
All right, anyone else wish to be heard on that particular suggestion by Ms. Lansing? How about Eric Menendez, counsel?
I haven't thought that all the way through. Our basic position is, what we are concerned about is confusing our jury by a series of questions about witnesses and events and behaviors they know nothing about. And secondly, by having our jury exposed to so-called bad acts or Wheeler-type acts committed by Lyle Menendez, and the spillover effect. If those things were taken care of in such a way, if it were possible, and I don't know if it is possible, if it were possible to avoid any of those things being brought before Eric Menendez's jury, I can't say that I would find Lyle Menendez testifying in his direct in front of Eric's jury a worse event than having him called as a rebuttal witness as to inconsistencies. I'm concerned about the specter of one brother being called solely in rebuttal for however minor the inconsistencies might be, and giving the impression that there's great conflicts where there may not be great conflicts. I mean, I look at it from that perspective. But one thing I do think should be avoided at all costs is this lengthy litigating of things our juries never heard about, and this impeachment of Lyle with bad acts that our juries never heard about that aren't properly before them. Whether the restricting and limiting and cutting out approach makes more sense, or the save them for rebuttal. So I think neither one is terrific, but I'd rather just not have him testify.
All right, did the people wish to be heard on this?
Your Honor, as to the Wheeler-type bad acts of Lyle Menendez, Eric Menendez's jury already knows by stipulation that Lyle Menendez was involved in the Ginsburg and the List burglaries. I mean, that's already there. The Princeton burglary, I don't know how that impacts negatively on Eric Menendez, and in fact could be used to his benefit, since that burglary predates the other burglaries, and the argument could be made that it was Lyle Menendez who is the instigator of the Ginsburg and List burglary. So I don't see how that is prejudicial to Eric Menendez. As the defense for Lyle Menendez talks about Craig Signorelli, there is reference in the 17-page letter of Lyle writing to his brother saying, "I don't hold it against you that you told Sig or Oziel." So at that point, I think in any kind of trial and with any kind of combination of juries, that all the juries are entitled to know what he was talking about when he talks about Sig. I think we know that's Signorelli. And I think that these defendants committed the crime together. It's been a joint defense. It's been a joint trial. And to allow them now to benefit from the fact that we have the two juries and manipulate the two juries would be a miscarriage of justice and deny the people the due process as well.
Well,
but now, is the defense proposing then that each defendant testify in front of their own jury, and then we would have the option of calling, for instance, Lyle Menendez in rebuttal in front of Eric Menendez's jury? Is that what I heard them say?
If you have proper rebuttal evidence, if you have impeachment.
Well, that's what Ms. Lansing said, but without the clarification of Ms. Abramson.
I'm not
I
certain.
don't know if,
Or the acquiescence?
yeah, I don't know if it was suggested that the defense would have a veto power over whether a witness would be called or not.
No, I'm not suggesting it. I think they can do that legally. And I think that, They can do that appropriately. Anyway, that's why I'm not sure why we're getting over this. But I would just want to say things like the escape plans, the 17.
What were you just saying? You felt that one defendant could be called by the prosecution to testify in the other defendants, before the other defendant's jury?
If they have proper impeaching evidence.
After
In
the
other
defendant has testified, he can be recalled by the prosecution before the other defendant's jury.
Yes, because I think he's made himself a witness at that point. I mean, for example, if one, defendant testified that, they.
Well, regardless of the
did something
specifics of it.
Yeah, but I mean, if they're clearly impeaching and inconsistent, it's like any other witness, I suppose you can call, to prove the same thing that he testified to in front of his own jury. If he testified to X in front of his own jury and the other defendant testifies to Y, I think you can call X to impeach Y on that issue because he's already waived his right against self-incrimination as to that piece of information.
All right, and that would be the position of Lyle Menendez as well.
In terms of whether that's the law or whether that's the lesser of the.
Well, first of all,
seven evils.
that's your position that that's the law. Those are people's
I
brief.
think that was the people's position in the motion they filed.
Right.
I will defer to Mr. Burt with regard to that, but I think we felt that it was an argument that probably would be persuasive, that they could be recalled. And certainly, given the
Well, I
alternatives.
want to hear the position of each defendant in that regard.
Given the alternatives we face, we would rather do that than have one of these hybrids of the in front of two juries.
Well, it's not a question of alternatives. It's a question of what you view as the law and whether or not you are going to make any objections if that was to occur.
We would not make any objection. Mr. Burt, I think, has a case in front of him.
No, I don't think we'd be in a position to make that objection if we urged the court not to allow one defendant to testify in front of the other defendant's jury. I don't think we could then turn around and say that it was not proper rebuttal in the circumstances of this case, regardless of what the law in general might be.
All right, let me just respond to something the prosecution said, then we can go back. I think people had something else to say. The prosecution talks about the defense manipulating the process of the two juries. Remember that it was the prosecution also that requested two juries. Had this case, and the reason the prosecution did so is the prosecution's concern that certain evidence would not be admissible in a trial where there was one jury and both defendants being tried before one jury. The prosecution was concerned that some of the evidence that has already been introduced in this trial before separate juries would not have been introduced or could not have been introduced in a joint trial with one jury. So the prosecution is the beneficiary of the two juries as well, in that the prosecution asked for two juries and the prosecution has testimony before one jury or the other that the prosecution had concern would not have been introducible if there had been one jury. Bear in mind as well that if we had proceeded with one jury, the trial number one would have obviously been much shorter. The people would have put on fewer witnesses in its case in chief. We would have gotten to a stage in the defense when the defendants would have had to make a decision as to whether one or both would testify. That decision could well have been different than it will be in this situation where there are two juries, because different evidence would have been introduced and different potential impeachment would exist than it does at this point. But the prosecution would have potentially been in a position, should either of the defendants had testified in a one jury trial, one jury instead of two, to use some or much of this evidence, or at least some of this evidence, in cross-examination of whichever defendant did testify. And then either the prosecution or the defense would have been in a position to introduce this extrinsic evidence that has already been introduced. We've already seen evidence introduced as to one defendant or the other that in a trial where there had been one jury might only have been introducible at all if brought out by cross-examination of one defendant or the other, and used to impeach that testimony if whichever defendant did testify in that hypothetical situation of a one jury situation. So at this point, the prosecution is really saying to the court, we benefited from the two juries by being able to introduce all this evidence either before one jury or the other that we might not have been able to introduce in a one jury trial. Yet we want to turn around and do it all again before both juries. So both sides are basically trying to take advantage of the two jury situation here, and it creates a perplexing situation that has to be dealt with. And this is a situation I'm sure that all the parties considered early on in the process before we ultimately elected to proceed with the two juries. But the situation now exists where it has to be dealt with. The proposal of the defense is that in rebuttal, if there is evidence by one defendant that contradicts or impeaches the testimony of the other defendant, then the prosecution would be in a position to call the defendant to offer that impeaching evidence against the other defendant. What is the people's response to that proposal?
The people's response is that is not acceptable. I just want to backtrack a little bit, Your Honor. Diane Vandermolen and Kathy Simonton and Marta Cano, for the most part, and Peter Cano testified in front of both juries as to specific instances relating to both of these defendants. And sometimes only one defendant was, there were incidences involving Lyle Menendez that were presented in front of Eric Menendez's jury.
Most of the evidence and that sort of evidence really is of no moment and really isn't the concern here. It has to do with other acts of impeachment or other evidence offered by the prosecution that only one jury has heard and not the other jury. That's really the concern more than anything else. Or the evidence offered by one defendant to impeach prosecution evidence that was offered only as to that one defendant. That's really the issue here. The major witnesses or the witnesses who testified before both juries, and specifically Oziel, that testimony, in my view, if that was the only bone of contention here, would be certainly subject to introduction before both juries, that Bruton and Aranda would not be a problem and wouldn't prohibit that. But we have all these other issues that are being raised and legitimately being raised by the defense that would potentially create confusion in that one jury has heard it and the other jury has not.
Well, Your Honor, I think there's a third proposal, which is that we conduct the direct and cross-examination the same way we did with Dr. Oziel, which is that certain things are put on in front of both juries and certain crosses in front of both juries, and certain other direct is done in front of one jury and cross is done in front of one jury. And that's how we proceeded with Dr. Oziel. And if, for instance, there's going to be direct examination in front of Eric Menendez's jury about many of the witnesses, like the Whalens or the teachers or the coaches, of which the Lyle Menendez jury knows nothing.
Well, the teachers and coaches, I can't visualize that as being an issue, really.
But Ms. Abramson indicated that of these 18 witnesses, she intends to ask on direct about many of them. We've only indicated that we would ask on cross about 5 of them. In fact, one of the things, Sergeant Edmonds' statement regarding from August the 21st is in front of both juries. So it's only 4 things. But the defense now is saying, well, we want to ask about all these people. Therefore, Lyle Menendez's jury is going to get confused. And so our answer is, if you want to ask about these subject matters, why don't we just do the same sort of cross-examination and direct that was done with Dr. Oziel? I don't see why that can't be done the same way that it was done for our witness.
Well, if it was done, then somebody would have to sit down and chart out those things that would be introduced only as to one jury, and those things that would be introduced before both juries. And then someone else, such as the proponent of the evidence should sit back and evaluate it as to whether or not it would restrict the impeachment of the witness that you're concerned about. That by eliminating this sort of evidence, you would then eliminate the potential of impeaching the credibility of the defendant who is testifying before the other jury. You might be losing more out of it than you're gaining.
Well, but in front of the jury pertinent to that defendant, once the other jury left the room, that we could continue to impeach the defendant.
Yeah, I'm sure you could, but I'm talking about the other jury that has only heard the portions that are introduced before both juries. Then you are losing the potential to impeach that witness before the other jury.
Well, there may be enough that can be used for impeachment that's acceptable in front of both juries to accomplish that purpose.
Well, that could, to some extent, could be a decision made by you as to how to proceed, just as the prosecution or the defense made certain objections as to certain evidence that was offered as regarding other witnesses.
We're at a disadvantage because we don't have a 20-page typewritten statement like the defense did for Dr. Oziel, so that we could delineate what would come in and what wouldn't.
Well, you certainly know from these lists that have been prepared, those things that one side or the other wants to go into, you know, which things that Lyle Menendez counsel want to ask about and what things they're concerned would be asked about of Eric Menendez. So you can certainly evaluate it with that in mind.
Certainly, but it still is difficult in a relative vacuum to say precisely how the cross-examination would go. And I don't, at this point, I think that as far as the Aranda statements, that, let me just argue by analogy. Nelson versus O'Neill and other cases interpreting it basically say that once a declarant takes a stand, that Aranda is not a problem. And what happens then is you get an extrajudicial, sometimes tape-recorded confession of the testifying defendant, which implicates the co-defendant. And I can't think of anything more prejudicial than that. And yet the courts say that that is acceptable.
I'm not disputing that, and I've already indicated that that wouldn't be a barrier here.
Right.
You can do that, and specifically the Oziel testimony.
Yes, and so to the extent that there are certain Aranda issues, which also carry with them 352 concerns, but which principally are Aranda problems, I think those things should be in front of both juries.
Well, as you get away from the commission of the crime and statements acknowledging involvement in the crime, and you get into other evidence, then you do have a problem. And
That's
you're
correct.
not responding to the argument made by the defense that some of these witnesses have been subject to impeachment. The prosecution elected to introduce evidence from Mr. Signorelli, and he has been impeached. The Eric Menendez jury has heard that. The Lyle Menendez jury has not. So that's different than playing a tape recording, which is there and the jury would hear it and all the evidence regarding it would be introduced before both juries. In this situation, the jury has not, at least the Lyle Menendez jury has not heard all the impeaching evidence introduced regarding Signorelli, as well as the Eric Menendez jury hasn't heard the evidence in regards to Glenn Stevens.
Oh, right, but hypothetically, let's say that Lyle Menendez testifies only in front of his jury, and I bring up the 17-page letter and I say, what is his statement here about Signorelli? I mean, his jury still doesn't have the advantage of having seen him, but I'm entitled, even in front of his jury alone, to bring that up, because that's a letter he wrote about the crime. So the defense is still faced with the same problem. I'm still going to ask him about Craig Signorelli, and his jury still won't have seen Mr. Signorelli. In addition, we do have a tape recording of Eric Menendez speaking with Craig Signorelli, in which he inferentially confirms that he made statements to Signorelli.
Well, but the Lyle Menendez jury hasn't heard that, and that was subject to examination. The tape wasn't played. It was through the examination of Detective Zoller.
Correct, but the tape will be played for Eric Menendez during his cross-examination. So to that extent, as far as Mr. Signorelli goes, I think that Lyle Menendez's jury is going to find out who he is, and they'll have to decide how to deal with that. But I intend to cross-examine him, whether it's in front of both juries or one jury. So, and the court says we haven't responded to the defense argument. What I've offered is a third solution, which is if the court is not inclined to let us go into these issues, these 352 versus Aranda issues in front of both juries.
Well, some might be and some might not be. would depend. But what I'm suggesting is that if that is your proposal, then somebody has to sit down and chart it out, and you are the somebody. Yeah, you can't just say, well, it's too difficult to contemplate, and I really can't do it because I don't know what's going to happen.
Well,
but this is my proposal.
Well, sure.
You can't do it both ways.
Right. Well, I would say that the Aranda issues, that is the statement, I'm going to certainly go into the August 21st statement that's in front of both juries, the September 17th statement where he talks about his alibi and what they did that evening and the habits of his parents, the 17-page letter, the escape plans, and the statements to Jamie Pizarczyk. And these are all things dealing directly with the crime at issue that are Aranda problems and also have 352 concerns. But I mean, you could say that about an extrajudicial confession as well, that's a 352 problem as well as an Aranda problem. But these are statements dealing directly with the crime, which should be allowed to be brought in front of both juries and cross-examined in front of both juries.
Your Honor, you see that's
All right. Are those the only issues that you intend to bring out, the 5 things that you've enumerated here?
Well, Your Honor, I'd like to look at my notes, and
those are the things we're most concerned about that we think are least admissible in front of
Well, obviously, the August 21st statement is
Yeah, that is fine.
not an issue.
But the escape plans, how that is a direct statement about the crime, the 17-page letter, which is written by Lyle and is his rumination, and the statements to Jamie Pizarczyk. There's no issue with Jamie Pizarczyk about whether, I mean, there's a statement to her that he killed his parents. That isn't even an issue. What they want to do with that evidence is to try to show that he is suggesting that she pretends something. That she pretends something. And that should never be brought out in front of Eric Menendez's jury. That has nothing whatsoever to do with him and is not a statement implicating him in the crime or explaining Lyle Menendez's involvement in the crime. That's precisely the sort of evidence that Eric should not have to have presented to his jury. That's exactly the kind of evidence the court was suggesting to the prosecution they might have to forego if there was one jury. It was precisely these particular issues.
Well, let's do it this way. The reality is that we have 2 juries, and there is a potential of still introducing evidence before one jury and not the other jury. And rather than just taking the broad approach that any out-of-court statement made by one defendant should be admissible against him and should be heard by the other defendant's jury, perhaps some further thought should be given as to the overall prejudice that might arise from such evidence being introduced. And it's potentially more than just confession to or admission to a crime, but it's evidence that relates to potentially other crimes being committed by another person, the other defendant, in this case, attempted escape, attempt by Lyle Menendez to have someone testify falsely to commit perjury. There was also a potential inconsistent statement made to this individual that I don't know if that was something the prosecution intended to go into or not. There are different levels of evidence that could be offered as to one defendant versus the other. And there can be some effort made to focus on how, if it's possible at all, to proceed with testimony before both juries as to the bulk of the evidence and testimony before one jury or the other as to other evidence. And rather than just shoot from the hip and suggest these things at this point, I think perhaps, or maybe I'm wrong, maybe you thought this through very carefully and thought about it, and you've decided these things would fall within a 352 analysis in favor of their introduction before both juries. Maybe you have, maybe you haven't. But it seems to me that they have to be explored in the context of a 352 analysis before they get introduced before both juries. and specifically the escape plan and the attempt to introduce false testimony. Those are matters that could be potentially prejudicial under Section 352. Have you also focused on the reverse of evidence introduced as to Eric Menendez that would only be introduced as to him and not as to the co-defendant?
In terms of cross-examining Eric Menendez?
No, as to, well, let's back up. You've just given me 5 items, actually 4, since August 21st was a interview that's before both juries. The other 4 items, I assume from that everything else would be introduced only as to the Lyle Menendez jury, anything else that was subject to objection by Eric Menendez. Is that correct?
Aside from the 4 things that we mentioned.
September 17th, the 17-page letter, the escape plans, and Ms. Pisarcik.
Yes.
Everything else you would be offering only as to Lyle Menendez and not as to Eric Menendez.
Yes, I would like to go over my notes again to make sure, but I believe that would. And Ozeal.
All right, well, I've indicated as far as Ozeal is concerned, tentatively, my view would be that that would come out before both juries, one way or another. That would be standard cross-examination. He has been here subject to impeachment in great detail as far as his credibility and as far as the specifics of a statement. The statement is pretty much documented and his testimony is pretty much based upon his statement.
Would that, Your Honor, could I ask a clarifying question? Would that indication by the court include statements made outside the presence of Lyle Menendez? In other words, Eric Menendez is on the stand. Is the prosecution entitled to ask Eric Menendez in the presence of Lyle Menendez's jury whether he made the statements that were made outside the presence of Lyle Menendez?
I would think so. That would.
Because our objection to that is confrontation problems aside, it's still a hearsay statement. It's still objectionable.
Well, it would be a prior inconsistent statement if he denies making it, and it's up to the trier of fact to determine whether he made it or not.
But that analysis, it would be our position, applies to Eric Menendez, not to Lyle Menendez, that the hearsay rule couldn't be avoided by in that situation because we're not offering the testimony of Eric Menendez. And that what's really happening there is it's just an indirect way of avoiding the hearsay rule of prosecution.
Well, in California versus Green, wasn't it the prosecution who called the witness? Maybe I'm misrecollecting, but wasn't it a prosecution witness who was called and then impeached by prior statement?
But the court, they're dealing with the confrontation objection. And the difference is, I think, that the hearsay rule stands, regardless of the confrontation. The court there is saying there's no constitutional violation, but the evidence, and that was a pre-evidence code case. And the problem with that analysis under the evidence code is under section 1200, it is still objectionable as a hearsay statement, barred by section 1200.
Well,
Even
but
if
the
it-
exception is it's a prior inconsistent statement.
No, I understand as to the declarant.
Well, the evidence code doesn't limit it to the prior inconsistent statement as to the declarant, does it? It just says it's an exception to the hearsay rule.
It doesn't, but it seems to me in the situation, in the context of this case, where it's the prosecution who is putting the witness in front of the jury and then setting up the prior inconsistency to use the hearsay statement against the other defendant, that's just an evasion of the hearsay rule.
It happens all the time when a witness is called and impeached by a prior inconsistent statement. It's not the defendant who made the statement, it's some other witness. And in this context, the other defendant is just another witness. And he is being impeached by a prior inconsistent statement. And it is an exception to the hearsay rule. Unless I'm missing something that's always been the law, it doesn't change whether the witness is a defendant or another witness.
I'd like the opportunity, if I could, to do a little bit more research on that specific point.
Sure.
Judge, I'm sorry.
Go ahead.
I'm a little confused now with the prosecution's most recent response to your inquiry. It is still my understanding that apart from the escape plans, the 17-page letter, the statements that Ms. Pisarcik testified to, and the and the 917 statement, they would still intend, with Lyle Menendez in front of Eric's jury, to cross-examine about the Princeton burglary, about Lyle's spending, about Lyle's statements to Glenn Stevens, all of that stuff.
No, I assume that they wouldn't.
Well,
These would
I
be
haven't
things
heard that.
well, that's the import of what they said.
In
Unless
other words, we have our list, which went through all those witnesses, Mr. Winskowski.
Yeah, that's why I asked counsel to go through and chart out, not you, the prosecution, since this is the prosecution's proposal, and come up with what it is that would be introduced during the cross-examination of the examination, to have some evidence before one jury and then stopping for examination before the other jury. And then I think everyone would be in a better position to evaluate what is gained and what is lost by such an endeavor. As I said, that when this occurs, the proponent of the evidence, in this case the prosecution, should evaluate it along the lines of how much evidence of impeachment is being lost by the procedure and whether or not the witness is then put in a false light before the other defendant's jury because of a loss of this impeachment evidence. So that's a separate issue. I'm not suggesting one way or another how you should proceed. I'm just saying that you should evaluate and list out what evidence would be offered as to both juries and what would be limited as to one jury.
There's one other piece of evidence that I think I would want to cross-examine Lyle Menendez on in front of both juries, and that deals with Mr. Whitkin. Now, there was...
Okay, he's testified before both juries, and they're basically the evidence is the same. There's some little wrinkle difference between one jury and the other, but it was a very small variation. There was some difference, but really it's not of any great significance, although I'm sure lawyers in their argument will find that there is, yeah.
So I'm conceptualizing this correctly. The way I'm looking at it is that we would seek to cross-examine Lyle Menendez about statements concerning the crime itself that have previously been segregated because of Aranda Bruton. I mean, that's the approach I'm taking, is cross-examining him about specifics regarding the crime, like the September 17th statement, the letter, statements to Ms. Pizarzik, and that we would seek to cross-examine him on those things in front of both juries, and then things that are particular to him and his background and his everything else, we would cross-examine in front of only his jury.
Okay, and
Tremendous.
okay, there could be, as far as those statements, a effort to bifurcate the evidence even as to that. Some could be before both juries, some as to one. I don't know. I think it's something that could be discussed further. There was some objection by counsel on attorney-client privilege. I don't know if that's the portion that the prosecution would be seeking to introduce anyway.
Yeah, they are.
I don't know what the objection is.
Okay, there was an incident where the two lawyers were present. That's mentioned in the statement. Is that what you're talking about?
Your Honor,
What page?
before we leave today, if we may, I'd like to approach ex parte and just let the court know what the problem, what the issue is here.
Okay, yeah,
It's
I
not
thought you said it
totally
was in
apparent.
the transcript.
It is
It is, but you
partially,
might not recognize.
Okay.
but there's some other information we need to provide to you. And
Okay.
I don't want to surprise you with it. So if we can give it to you tonight, you can think about it. before
Okay,
tomorrow.
let's then recess and you can come back tomorrow. But when you do, I want the prosecution to have a list of these things. And if there is a suggestion of even as to a particular witness and impeachment using that witness's testimony or statements or certain evidence to bifurcate between one jury and two juries. look at it in that context, and then use the flip side of looking at Eric Menendez's testimony and as to how you'd approach it if you followed the procedure that you're suggesting. Bear in mind, this is all virgin territory. This is not something that any appellate court has addressed, as far as I know, that the appellate courts, when talking about two juries, basically say that it's a good idea under certain circumstances, but they have never addressed this particular circumstance. So we'll resume tomorrow at 9 o'clock, and counsel are to present to the court those lists that I've suggested here. And we'll clear the courtroom and let counsel make their brief presentation as to the attorney-client privilege. Okay, why don't you do that then? Okay.